Good morning, everyone. I'm Rick Bierschbach. I'm the Dean of Wayne State University Law School. I have the privilege of welcoming you all to this fantastic conference put on by the American Bar Foundation on emerging insights from access to justice research. And it's my great pleasure to do so. We've got a really fantastic day ahead. I'm going to live stream the program because I have to run and go to a bunch of meetings. But I was saying I wish I could skip out on my team's meetings and just be here in person because it just looks fantastic. I want to thank the American Bar Foundation for putting on a program of this caliber and for sponsoring it. I want to give special thanks to my colleague on the Wayne Law faculty, Professor Kirsten Carlson. Where is she? She's there. Okay, good. Thank you. Who helped make the connection to get this conference here. And part of the connection there is that Professor Carlson is currently serving as an ABF and JPB Foundation Access to Justice Scholar. She's also the Marilyn Williamson Endowed Distinguished Faculty Fellow this year at our Humanities Center. She's also a faculty affiliate in our political science department, and she's many other things, but she is every bit as impressive as all of those titles make her sound. So Kirsten, thank you for making this connection. And let me just thank a few other people who were instrumental in organizing this conference. Rebecca Sandefur, you're going to hear from Becky in a minute, but she's the director and professor at the Sanford School of Social and Family Dynamics at Arizona State, and she's also a faculty fellow at the ABF. Elizabeth Mucha, I don't know if Elizabeth is in the room or still outside, but Elizabeth has been really critical in pulling this together from the ABF, as has Matthew Burnett. And Matthew, I hope you're in the room somewhere so I can, right next to me. This is what happens when you're looking out at the crowd. So I also want to thank my colleagues at the law school for helping to pull the logistics of this together. And then finally, I just want to say I hope you all enjoy your time here at Wayne State and in Detroit. It's a beautiful day. We're in the beautiful McGregor Memorial Center. At lunch, walk around, take a little tour if you have time. And maybe some of you will be staying and going to the Equal Justice Conference downtown in the next couple days. So if you get a chance, check out the rest of the city then too. Now I'm going to turn it over to Becky to continue with the program, and I'll see you all again at lunch. Thank you.
Taller than me. Everyone is taller than me. It's wonderful to see you all here. Thanks so much for being here. Thank you to our scholars and to all of you who are coming from different parts of the country and the world to talk together about emerging insights in research and what we might do with them and what the next emerging questions might be. I want to share our thanks with Wayne State for hosting us. This is a wonderful space and it's great to be here. And I also want to thank them for the weather, which also is this nice day between 2 days of rain. What you're going to hear about today is one of the projects of the Access to Justice Research Initiative at the American Bar Foundation. So that initiative is at this point about 14 years old, I think. And we do research there ourselves. But another really important part of what we do is try to grow the capacity of other people to do research and to build a field. And so some of what you're going to hear about today is from that kind of work. But we also have a project called the Justice Data Observatory, which is about growing access to justice scholarship and identifying it around the world. We also are, so your Bureau of Justice Statistics, which is part of your Department of Justice, collects all kinds of information about criminal justice. That's how we know how many assaults there are every year. That's how we know how many people are incarcerated in different kinds of forums and supervised by different parts of the criminal justice system. But they have a current initiative, which is partly about research. It's about producing what would be the prototype for a national civil legal needs survey, which would produce information that would help us understand what's going on, but also make important arguments about what to do about it. And so, yes, part of that is research, but part of that is creating a resource that will be a resource for government statisticians, for researchers, and for different kinds of practitioners and policymakers. And that the part of that contract that's about developing that survey is at the research initiative at the ABF. So we're excited to be working on that. But the centerpiece of this field building work is really the ABF JPB Access to Justice Scholars Program. And you'll be hearing from a number of scholars about not just their own work, but the fields in which they're working or the sort of general challenges and insights they're getting from what they do. We're delighted to have them here, and they're here in part through their own ingenuity and initiative and dedication to this work. And they're also here through the really generous support of the JPB Foundation, and so I want to be sure to acknowledge them. Now it's my privilege to introduce our first speaker, who is Mr. Harold Pope. Come on up. Harold has had an incredibly distinguished career, both as an attorney, but also in a range of really important service roles to the profession and to the country. So since after receiving his JD from Duke, he has been deeply involved with the American Bar Foundation. He's currently a board member. He's also a Sustaining Life Fellow. He's had a range of important service roles with the ABA, and he also is a past president of the National Bar Association. And so we're quite honored to have him here to open up this event with some remarks. Thank you so much, Harold.
Well, as she said, my name is Harold Pope, and I'm proud to welcome you all today here on behalf of the Board of Directors of the American Bar Foundation. I also like to welcome you to Detroit because this is where I live. So please do the program today, do the conference over the weekend, but go out and spend money here in Detroit. We want to. Oh, I'm sorry. Please go spend money out here in Detroit. If you get nothing else from my remarks, that's the most important thing for you to do. So I want to begin by thanking Wayne State University School of Law for hosting this program. For more than 70 years, the ABF has operated among the world's leading research institutes, studying the law, legal institutions, and legal processes. ABF scholars conduct large-scale, interdisciplinary, empirical research projects which help us better understand the way laws in society interact. Projects have included studying attorneys in China, comparative constitutional analysis, diversity issues both here and abroad, and of course, access to justice. Access to justice is an important theme across much of the ABF's work, and we're so grateful to Becky Sandefur and the Access to Justice Initiative staff for all the work they are doing to help mentors, scholars, and grow the field. I also want to take a moment to recognize and thank anyone here who are fellows of the ABF for your support of this research and programming. We would not be able to continue doing this type of cutting-edge interdisciplinary research without the fellows' generosity. While being a fellow is a profound honor, you are also a part of something that's bigger than that. You are part of shaping the way law and society interact, so thank you. On behalf of the ABF Board of Directors, we're so grateful to all of you for participating in today's conference, and I look forward to the important conversations and insights from today's panel discussions. Thank you for coming.
Welcome and good morning. My name is Matthew Burnett. I'm the Senior Program Officer for the Access to Justice Research Initiative at the ABF. And I'm delighted to be able to moderate this first panel, which is on a topic or theme that's very close to my heart, which is research practice partnerships. When I worked with Becky at OSF, my critique was often, this research is great, but what does it actually have to do with real world policy and practice? And little did I know, a few years later, I would be put to test to try to figure out how to make that happen. We have four incredible scholars today who are going to talk about both their research, ranging from housing justice to consumer debt and debt collection, ways of understanding evaluation of legal services programs serving Indigenous communities, as well as how to evaluate brief advice. But what they're also going to do is talk about the ways in which that research intersects with legal aid and community-based organizations. And so we've asked them to both share their work, but also share their insights about those partnerships. We'll then have Nikole Nelson, who was formerly the executive director of Alaska Legal Services, where she served for almost 25 years, and has navigated lots of different research projects, including most recently. Thank you. Closer. Including most recently the partnership with University of Minnesota on an NSF grant, Civic Innovation grant, to evaluate community justice workers in Alaska. So she's going to reflect on those experiences. We're going to go in order of the speakers in the program. And so I'll just introduce them briefly. The far end of the table is Margaret Hagan, who is Executive Director of the Legal Design Lab at Stanford University. To her left is Neel Sukhatme, who is a professor and the Dean of Research at Georgetown University Law Center. To his left is Kirsten Matoy Carlson, who was introduced earlier as a professor here at Wayne State Law. And then to her left is Claire Johnson Raba, who is assistant professor at the University of Illinois Chicago School of Law. And so we'll kick things off with Margaret. Thank you.
Everyone can hear me okay? Well, good morning. Thanks so much. I have the privilege of going first. So if this works, let's see, slides. Just a second, no problem. While we're doing that, maybe I could just understand a little bit more about who's in the audience. So who here would identify as an academic or a researcher, someone coming from a university? Great, okay. Who here would identify as kind of a legal practitioner, whether you're a legal aid lawyer, court help staff, a justice worker? Who here would identify as like a philanthropist, a strategist, someone who's looking at making the whole system better from a big point of view? Anyone I didn't capture role? Court administrators, people, okay, thank you, John. Well, that's helpful. Would anyone here identify as a regulator? I'm really interested. Any regulators in the house? Great, okay. Hopefully I can speak a few points that will resonate with what you do in your everyday job. So the point of my presentation is about how we start measuring more clearly and more systematically what makes for good legal help, what makes for bad legal help. And I'm thinking about a particular context of legal help. There's many different kinds of legal tasks, legal services that are provided. In the presentation, I've zoomed in on one, and that is the kind of question and answer, brief advice interaction that happens all the time. It happens when people go to Google and type in a query. It happens when they call a hotline or a chat line like Housing Court Answers in New York City, and they ask, I got this scary packet in the mail, what should I do? It happens when they go on a virtual clinic like ABA's Free Legal Answers, and they write a paragraph about their story of the problem they're having, and they wait for a lawyer to give them a paragraph or two back. It happens when they go to Reddit. Great. Okay, so I am really interested in how we start measuring the quality of what is given back to that person who presents a line, a paragraph, 3 paragraphs about their problem, and is looking honestly about how to start their legal journey, if they should start it at all. How do we start thinking about real clear quality benchmarks for that interaction in particular? So that's the kind of guiding research question that motivates me, but I find also motivates a lot of on-the-ground frontline practitioners and regulators. How can we tell if, well, generally legal services are doing a good or bad job at helping people get a better legal outcome, life outcome, helping them versus harming them? I know that many organizations do this, and regulators think about this a lot, but a lot of that strategy has been around, we know it when we see it. We know harms when we see them, we know quality when we see them. We don't necessarily have a checklist that we train people on or that we use to review past services or past interactions. but especially as we see two big trends hitting civil legal services this year in particular. One would be generative AI and all of the eagerness and openness, both from the public, but also from practitioners in legal aid, court, and other help providers, now exploring this new world of providers, this new world of services that might be possible with generative AI. And another big trend of community justice workers that builds on these past legacies of navigators, paraprofessionals, triple LTs, call it what you want, but new kinds of people entering into the legal help space. We need to think more clearly about how can we measure if these new providers are safe, are providing quality help. We don't actually measure our current providers in a clear, standardized way, but especially if you're, as I am, very focused on generative AI and if it's doing a good or a bad job, we need to think in clear, standardized quality benchmarks to be able to say that. So this is the research challenge that I've honed in with partnership with kind of frontline practitioners. I ran a big workshop online about April of last year in partnership with the Self-Represented Litigation Network, SRLN, in which we had about 100 folks, justice professionals in that network, talk through the opportunities and the risks about using generative AI in legal services. And from that, I started to find some of the patterns about how practitioners think about and measure quality. From that, I formed a research project last year that's taken two parts that I'll walk through today about can we move from this kind of blurry vision of what makes something good or bad, helpful or harmful, to something that basically engineers could understand. In my context of exploring generative AI, we need to be able to communicate with the tech companies, whether it's the big ones like Google, Meta, Anthropic, OpenAI, who are building these systems and evaluating them. We as a legal community need to communicate to them what makes something good or bad, or else they can't develop better legal performance. We also need to be able to talk to the small startup developers who want to serve the legal aid and the court community in particular. So I've zoned in of all the different kinds of service provisions, whether it's drafting documents, reviewing discovery requests, preparing a person for a trial. I've zoned in on a particular legal task, which is this kind of brief answer. A person gives a line or a paragraph. What does the system or the provider or the person give back? And so why I think and why many of the practitioners are interested in a stronger, clearer quality benchmark is because it helps us actually understand if these new providers, whether they're people without a law degree or a new AI system, are actually doing a good job or not. Can we use them? Can we integrate them into our current legal aid or court help services? Can we actually use that quality benchmark to train and review our existing providers, lawyers, paraprofessionals, justice workers in a better way? And when we think about regulation, how do we get smart that we're not totally chilling or freezing out these new possible service models, but that we have smarter empirically based regulation that's not based on anecdote or emotion? So what I've been doing starting November, I did a first round of a research study with my team, and then we've done a second round in the spring to kind of build a clearer first version of a benchmark. So I started in November and December last year with 30-minute to 1 hour interviews with 21 different justice professionals who work from legal aid to court staff to law librarian to law school clinic directors. And in those interviews, I asked them to imagine that they were brought in by a technology company to talk to engineers at a technology company about what would make a chatbot's response to a legal question good or bad, helpful or harmful. And I presented them with about 22 different specific criteria where they could rate technology developers, pay attention to this. If you get this right, it's actually really important for a person's life outcome. Or technology developers don't actually pay attention to this criteria, like down rank this priority. It doesn't really matter to a person's outcome. You can't see all of these. I'm happy to share my slide, or there's blog posts and articles on this. But there's about 22 different criteria that I presented to the providers. I would group them loosely into what actual content is provided in that paragraph or two that the system gives back to a person, the accuracy, the detail level in that response, the presentation and formatting of it, the presence or lack of bias in that answer, warnings, disclosures, and other things to promote informed usage, and what sources have been used for the content. So I went through each of these possible criteria one by one, and the professionals ranked them on a scale of 0 to 6 about how important they were. The most important criteria that these 21 professionals highlighted were absence of toxicity. So a system, whether it's a human or an AI system, should not be giving hateful or inflammatory language back. Plain language, accessible, clear writing. No misrepresentations of forms or other procedural rules, and no misrepresentations of the actual law. So kind of absence of hallucinations, absence of misrepresentation. Still important, but not as important, were about actionability, clear next steps, good formatting, other things. The least important criteria that the professionals said don't actually give as much weight to these were around citations to the primary law, robust, comprehensive, detailed answers, or disclaimers to talk to a lawyer first before using the advice. So a lot of the focus about where we should actually focus our quality measurement is around absence of misrepresentations. So no out-of-date laws, no laws from the wrong jurisdiction, especially no wrong deadlines or procedural rules. So case law, statutes, less important about the misrepresentations. The key thing is getting the action steps right. Also, kind of plain, non-toxic language. Here are some quotes that illustrate the thinking about what makes something good or bad. So a legal aid technologist said, it's all about the clear steps. We need to get people to avoid getting tripped up on procedure. Don't focus so much on, is this thing a valid defense to eviction? Rather, you should be focusing on how many days do you have to respond. Quality also means not overwhelming people with too much detail. So we shouldn't be encouraging developers or professionals that quality means more, more, more. Actually, it means restraint and really prioritized, clear information given back. So not stating the law in a lot of detail, less is more. We want to give people useful information, referrals, explaining the basics. That's the win. There was a lot of pushback against putting emphasis on disclaimers and always handing people off to the usual talk to a lawyer first that actually has harm, and not to over prioritize legal accuracy. This was really interesting. The laws change all the time. As soon as you put something online, it might be out of date or wrong for a specific courthouse. So don't over penalize or regulate groups just because they get the law wrong once or twice. It happens to human providers too. So if we kind of ban AI because it gets some procedural details wrong in some instances, we might be doing more harm than good. So quality is about good, actionable, big picture, not too much detail. In the second round of research, we actually had a new round of 21 professionals play a game in which we gave them a sample question and AI answers sourced from GPT 3.5 and 4, all about landlord-tenant law. And we asked them to actually rate the AI's quality. So this is the game. They were given the question posed that we had sourced from interviews with real people, and then output about what the AI told a person in response, and we had them vote on those different criteria, whether it was good or bad. We also asked them to list out any benefits they saw the AI providing versus harms. So the main harm that practitioners saw were about wrong dates and procedural rules. Getting, Georgia law wrong about what the requirements are, and then a person could misrely and lose their home. Or getting the dates wrong, calculating days, not including business days and other things, then you miss your opportunity to respond. A good legal answer, still accuracy is important, but a lot of the benefit that an AI answer or a community justice worker answer is encouragement and assurance to keep going with the process. That even if it's not, fully, totally correct, if it keeps a person going to the next step, there's a lot of value there. Bias also was found to exist in more ways than we had expected. We had expected it to be mainly about demographic groups, people getting different information based on presumed identity. But the practitioners were highlighting other kinds of bias problems. Bias towards hiring a lawyer. Why is this AI always telling a person to hire a lawyer? This is biased. Or bias towards a landlord's perspective versus a tenant's perspective. Why is this AI telling me the rules and the next steps that presumes I'm a landlord, I'm a tenant? Why isn't it giving tenant-oriented information? So we should be thinking about auditing for that kind of bias. So out of that, we've kind of refined how we're evaluating what we're looking for in our upcoming audit. And now we're going to make use of all of this research to actually run yearly audits of the major AI platforms, of what's now Google Gemini, formerly Bard, of OpenAI and its current models, of Anthropic and Claude, maybe of Meta, if Meta is going to push AI on everyone. Because now we want to see how good are these leading platforms that we know people are increasingly going to for life and legal problem solving. How do they perform on the metrics that frontline practitioners say really matter? And we really want to make sure that as we study the performance of these platforms, we are not going to have regulation that's based on headlines about one lawyer in one place using ChatGPT with incorrect case law and all the problems that occurred in that case. That's not a good way to regulate. Neither is regulation based on a study of only focused on hallucinations. We know hallucinations is the main harm that a lot of people are thinking about, and when there's studies focused on the number of case law hallucinations, that can really affect how regulators might crack down on AI. We think, though, from what we're hearing from frontline practitioners, that measuring the amount of hallucinations obviously matters, but we also need to be measuring possible benefits like this sense of empowerment and assurance, clear actionable next steps. And really the main hallucinations that we're worried about is hallucinations of service organizations, like inventing legal aid groups, inventing legal aid hotline phone numbers, inventing different dates that you need to file your eviction answers by. Those are the hallucinations that really matter, and that's what we should be focusing our evaluation and regulation on. So I'll just close with the idea that I'm really excited that with these kinds of research practice partnerships, we can start to regulate in ways that direct responsible AI development in ways that will benefit both frontline practitioners and the public. And hopefully we will get kind of a leaderboard approach to regulation where if we can communicate what makes something good or bad in the legal context to this whole world of engineers who are spending all their time building AI systems, we might be able to get them to compete. Who can do the best at answering legal questions? Which of these models is going to get the accolades versus the shame on how they answer people's eviction, landlord-tenant, debt collection questions? That's the kind of virtuous cycle we want to be inspiring right now. So hopefully when we check back in a year, I'll have a leaderboard to tell you who's doing well or poorly. So thanks so much. I'll pass the baton.
All right, well, while we're waiting for the slides to go ahead and come up, I'll go ahead and just introduce myself a little bit. My name is Claire Johnson Raba. I'm currently an assistant professor of law at the University of Illinois, Chicago. I'm also a co-PI and a researcher with the Debt Collection Lab, which is a project at Princeton University's Sociology Department. I was a legal aid attorney for 10 years. I started and ran the consumer law practice at Bay Area Legal Aid in the San Francisco Bay Area. And a lot of the work that I did there was doing unbundled services and working with unrepresented litigants. So now that I'm in academia, my research really focuses on how can we study and how can we change the dynamic and the power differential that goes on between courts and unrepresented litigants, particularly when it comes to people who are hailed into court without their consent. So it would be tenants and debt collection, primarily debt collection defendants. So I'm going to talk today. I'm also an Access to Justice Bar Foundation Scholar, or American Bar Foundation Access to Justice Scholar this year. And there we go. And so I'm honored to work with Becky and everybody else with the ABF and my time that's about to conclude here as an ABF scholar. The artwork here in my PowerPoint is from the debt collection lab at Princeton. Part of what we do with the debt collection lab is we work on bringing dignity to debt and talking sort of, do I press this to go forward now? Do we need to start it first before I can press the button? Okay. Great, okay. Okay, so today I'm going to be talking about using research, empirical research to solve the engagement gap for unrepresented litigants in debt collection lawsuits. So I'm actually talking about a project that is funded by two funders, both the ABF and also the State Bar of California. So the research partners on this project are myself at UIC Law, and the researchers on that are myself and my student research assistants. Our legal aid partner is Inland Counties Legal Services, which is in the Inland Empire, serving Riverside and San Bernardino counties, two very large geographic and population counties and high poverty rate counties in Southern California. Our other research partner is California State University, San Bernardino, where I'm working with sociologists, criminologists, and social work students and professors. We are engaged in studying why people do not respond to debt collection lawsuits. So this is a collaborative project that started in part because the State Bar of California was seeking to fund legal aid partners who would increase the services delivery to consumer defendants throughout the state of California. And so I was working with colleagues there on a couple of other projects. I had developed some legal technology tools and guided interviews for them in DocAssemble. And I proposed to them, well, how about as part of this grant, we include a research component where the scholars research why people are not responding to debt collection lawsuits. And then we provide that information back to the legal services provider so the legal services provider can improve their services delivery and meet more people. I also built on some prior research that I'd done studying debt collection lawsuit data. So the data we get from the courts. But the data we get from the courts only tells us about people who engage with the courts. So the data we get from the courts tells us a lot about the debt collection plaintiffs. It tells a lot about their attorneys. It doesn't tell us very much about the 91% of people whose debt collection lawsuits end before they've ever spoken to a lawyer or filed anything with the court or sought assistance from a court self-help center, right? And so this is a twofold project that has this sort of intentional direct component because Inland County Legal Services over the 3 years of the State Bar Grant will increase the services delivery that they're doing through their community-based clinics. And also during that time, my colleagues at San Bernardino and I are engaged in reaching out to people who didn't respond to debt collection lawsuits, asking them in qualitative research interviews why they didn't respond, what were their self-help seeking behaviors, dovetailing a little bit with some of the research that Margaret has done at the Legal Design Lab, trying to find out where people do go for help. How do they conceptualize this thing that has occurred when they get sued on a debt collection lawsuit? So we're gathering data based on some prior data I'd gathered from the courts. Our research questions in this project are why do consumer to defendants fail to engage with the civil legal system at such a high rate? We're really interested in knowing what role do litigant perceptions of lawyers and of the courts play? We're also interested in whether or not there's a difference between people who have been criminal legal system involved and people who have not, particularly people who might carry court debt from the criminal legal system. Does that affect their perception of and willingness to engage with the civil legal system in these cases? In a second paper that we'll be working on next year, we're also going to be looking at, does the language spoken at home make a difference? If people speak a language other than English at home, does that change their engagement and their perceptions, right? And then a third piece we'll be looking at is What is the role that do the debt collectors themselves play, right? Does a debt collector calling someone up and speaking in Spanish about the debt and saying you don't have to go to court if you settle this debt, does that make them less likely to engage with an attorney or the court system? Are the debt collectors playing an intervening role? But the goal of this is really, in part, this is normative, right? We're like, how can courts and legal services providers better serve defendants in debt collection cases? We do have a strong legal services program in Riverside and San Bernardino County. And so how can inland counties and Legal Aid Society of San Bernardino do a better job? So some of the things that we're studying, right, this is sort of what I was talking about. We are studying and we're asking people about their perceptions of courts. California, like 5 other states, also has a filing fee. It's a pretty complicated process to file a responsive pleading, file a filing fee, or fill out a fee waiver to see if you're eligible. So are there procedural burdens that are standing in the way, or are there substantive barriers, right? Are people not sure if they have any contract defenses? Do they understand that they have legal rights they can assert? So these are the things we're asking people about in really open-ended qualitative interviews where we're asking people about their perceptions and what they did when they received the summons and complaint. So I'll just point a little bit to why this is a problem, right? So in some of my prior research, I scraped about 2.2 million records from debt collection lawsuits over 11 years, determining that debt collection lawsuits comprised as high as 37% of the civil lawsuits in California, right? Debt collection lawsuits and what we call, lawsuits in the poor people's courts, so comprising an increasingly high volume of the civil courts and state courts throughout the country. So this is the basis from which we drew our sample in Riverside and San Bernardino counties. Well, as part of my work with the Debt Collection Lab, I've also published a couple of policy reports last year. So these are available on the debtcollectionlab.org. These also look at these are the results of my analysis of the debt collection lawsuits in California, and really part of what drove the inspiration for this project, identifying really how the disparate impact of debt collection lawsuits in state courts and how that falls unevenly on non-white communities, and also how the courts are at this point really serving debt collection plaintiffs because debt collection defendants are not finding their way to court. There's also another paper that I've got coming out, it's forthcoming in the Review of Banking and Financial Law called Pay to Plead, and this does a deep dive into what's going on with the filing fees in California, really looking at those procedural barriers. So again, the policy reports and this paper, they study what's going on in the courts. What we're doing differently, and the data shows us, right, that the outcomes for consumer defendants who respond are significantly different from those who don't respond, right? You're more likely to get a dismissal, much less likely to get a judgment, much likely to get your wages garnished if you respond to the debt collection lawsuit, right? But we don't know what's happening in those settlement agreements. So one of the other things that we're studying in our qualitative interviews is what goes on in those settlement agreements. For the people who settled their cases out of court, are they agreeing to pay the entire amount over time, right? Is this actually a good outcome? And is this a way in which the legal services program could intervene and be a better assistance to negotiate a more fair outcome? This is, again, the court record data shows us the volume of repeat payer player plaintiffs in debt collection lawsuits is really concentrated among a very small number of debt collectors who are suing people at the rate of 200 to 300,000 people in California courts every year. So I'm going to move this along a little bit so I have time to speak a little bit more about our partnership here. I'm not sure where I'm supposed to point this. Okay, so the two papers that are in the two pieces that we're working on that are coming out of this is Uncivil Proceedings, which is litigant perceptions of civil debt collection lawsuits from a reentry perspective. Again, these are with my colleagues who are sociologists and criminologists at California State University, San Bernardino. And this is looking at the difference between perceptions of people who are criminal legal system involved and people who are not. I'm also working concurrently on a piece that's about the partnership itself. Studying poor people's courts is inherently a local thing to study, right? the solutions are inherently community-based. The legal aid partners are local within the community. The needs of the community differs, the demographics of the community differs from state to state and community to community. So this project studies 2 counties in California, right? So I'm proposing that the kind of work that we're doing, the kind of partnerships that we're creating can be replicated throughout the country. And that law school clinics are actually very well positioned to take on some of this work. And I don't know where I'm supposed to be pointing this out. There we go. So what I'm doing in the second paper is using this project as a case study to talk about the ways in which legal aid partners, law schools, clinics, scholars, and researchers can work collaboratively to better understand what is going on in their courts and to improve the services delivery. One of the things that we're doing in our study that we recommend doing is using the culturally competent bilingual qualitative research methods. So for that purpose, we're not sitting here at the University of Illinois Chicago doing our Zoom interviews. We have Masters of Social Work students who are from the community who are engaged in the direct interviews that are happening in Spanish and in English. We're partnering, this grant comes from the State Bar of California, and by partnering with the legal aid program that is local within the community, we're keeping the answers we find and the findings close to the community that we're studying. We're making recommendations that are specific and unique to the needs of the community within Riverside and San Bernardino counties. So in this paper that I'm working on, I'm setting out a roadmap for how direct services, legal aid clinics, and law schools can engage in similar empirical research by partnering with legal aid partners. And that this can also drive things like grant applications for legal aid partners. The more data that we have, the more legal aid partners can show unmet need and the reasons that they should receive funding from philanthropic organizations, from state funders, from federal funders, in order to improve their services delivery. Empirical research with legal aid partners also means that we can show measurable outcomes. So we expect to be able to tell the State Bar at the end of the 3-year project, not only that ICLS has served more people, but that ICLS has gained a better understanding of how they can reach some of that 91% of the population who doesn't already seek out their services. So bridging that legal knowledge gap of people who don't understand that, how a lawyer or how the courts might be able to help them in their problem. So what we're doing here is not only doing this one project sponsored by the ABF and the State Bar of California, but we're working to create a replicable model for legal aid and research partnerships going forward. Thank you.
I want to make sure I know how to work everything. Good morning. All right. First of all, I want to welcome you all to Detroit, or Wet'nong, which is what my Anishinaabe relatives call this place. I hope that you thoroughly enjoy your stay here. I want to thank Becky and Elizabeth and Matthew and everyone at the ABF that made this possible. And I want to thank the other people on my panel who did such a nice setup job for me. Claire did a great job of telling you all why we should care about the kind of research that we do and working with legal aid organizations, because it can help influence funders. That was added to by Margaret, who also pointed out that it can help with regulation. She also gave us a really good background for understanding why we care about the measurement of effective legal services. And I'm going to talk about that in a very different way than she did. And I'm also going to talk to you about a research project that was very much initiated by practitioners and approach it from kind of that standpoint. So it's a little bit different from what we've talked about so far. And what I'm going to talk about is a project that I have been doing with a legal aid practitioner, a legal services organization. I don't know how to push the button either, apparently. That serves Native communities here in the state of Michigan. And this project came about because they actually reached out to me as an academic and said, we're really, really worried about what we are being asked to do, which is measure outcomes. But the outcomes that funders want us to measure, we're not sure that those really reflect what we do as a legal aid organization. Because we provide a certain kind of specialized services to a marginalized community. And what they want us to do is they want us to measure direct case outcomes for individual clients. But the truth is that the provision of legal services in Native communities has never been about solving an individual's legal problems and sending them on their way. It's always been much more complicated than that, because from their inception, the Legal Services Corporation funded programs for Native communities have always served tribal governments and tribal communities as well as individuals. And so they were concerned about this. So we started a collaborative research project to evaluate whether the existing measures reflected the client community and to think about how we could craft outcome measures that reflect a community's values and experiences rather than just what the funder cared about. So what we're trying to do is we're trying to improve the measurement of legal services delivery by considering what the clients care about or taking client perspectives into the equation. What this ongoing research has done so far is it reveals that there's a disconnect between what funders care about and what the client receiving the services cares about in terms of legal services delivery. And that suggests that we need to come up with frameworks for measuring outcomes that reflect the community as well. Because if we're funding legal services and they're not really serving the community, then we kind of have to wonder what the purpose is if we're not improving what they care about. So what I want to do is I want to talk a little bit about the research and then a little bit about what it's been like working with and on a project that is very much practitioner informed and collaborative. So I want to start with a little bit of background because I think there's a couple of things that are important to know about measuring outcomes in this particular space and about access to justice in Indian communities because it's a little bit different than the rest of the world. And it's different because, as I said, okay, Claire, this is really hard. All right, it worked. And I really need the projects on generative AI because if you haven't noticed, I'm completely technologically challenged. So this is the old school way to measure things instead of like, let's worry about the newfound exciting technology. So this, as I said earlier, when legal services were developing, they developed a specialized program for legal services in Indian communities because of the historic underrepresentation of both tribal governments and individual Native Americans. And so they came up with specialized funding, but also the idea that what legal services in Indian country did was they represented tribal governments or communities in addition to individuals. And they address a set of issues that most people don't face because they're issues that are particular to Native communities under federal law. So things like legal status as an Indian, tribal treaty rights, and jurisdictional issues that most communities don't face. What this means is that it makes access to justice issues in Indian country multi-layered and multi-jurisdictional because oftentimes you have legal aid organizations that are dealing with state, federal, and tribal courts that are dealing with both individual clients and community-based clients and a set of legal issues that most people remain unfamiliar about because they are extremely specialized. It also means that you're dealing with a set of issues that exist in the shadow of colonialism because you're dealing with a population that has its own set of traditions and historic governance, but has to operate within federal law, which often dictates the types of courts and legal procedures that they have to provide to their clientele. At this point, it is also very much a transitional space, and it's a transitional space because in the last 50 years, we have seen a shift in federal policy that is more open to recognizing tribal sovereignty, which means that you have active and evolving development of tribal courts. There's over 300 tribal courts in this country, all of which operate with their own sets of procedures, mind you, informed very heavily by federal and state law, but it's a very complex system that is changing. And so that's some important background for understanding what we're doing. And then when we think about outcomes measurement, this is a fairly new area. I'm going to figure this out by the end, I promise. Oh, here. All right. It's fairly new. The Legal Services Corporation started mandating it for their programs in 2016. And there has been little empirical research on measuring these outcomes to date. There is very little investigation at this point about client perspectives on the outcomes of legal services delivery. And it feeds into several other literatures that I'm not going to go into because I'm going to be told I have to be quiet soon, that we can talk about. But basically what was left open as a question and that we've really been trying to think about is whether and how existing outcomes relate to client perspectives. So working with Michigan Indian Legal Services, we came up. There we go. Oh, see, now I went too far. Maybe. Okay. With some research questions that we wanted to look at, we're thinking about how do the current measures compare to what the Native community cares about, and then thinking about how the measures can be crafted to reflect a community's perspectives. And so we came up with a research design where I basically am doing a case study with Michigan Indian Legal Services on the legal services delivery that they provide to Native communities in the state of Michigan. It's to investigate and compare what exists with what people care about. And we have been involved in a lot of data collection in the last year, starting by looking at the documents to identify current measures set out primarily in the state of Michigan by the state bar. Looking at what those are, I've done some interviewing with legal aid lawyers to see what their experiences are with it. And then the bulk of the work has been focused on talking to the client community about their justice experiences and legal services delivery to get a sense of what they value and they think matters when it comes to outcomes in legal services delivery. And so the slide, if you're curious about what the interviews look like, they give you an idea of who I've been talking to in the community. And what basically is emerging from all of this, oops, I went too far. How did I go too far? Oh, because I forgot I had a slide in between. Is if you start with looking at what the current measures are, this is just an example, so you get a sense of what current outcome measures in the state look like. These are all of the outcome measures that get reported by organizations funded by the state bar for providing legal aid. They can basically be put into 4 categories: prevented eviction, extended time, overcame unlawful interference, and preserved housing subsidy. And what happens when you actually go out and talk to the community is you find out that they don't really talk about their experiences and the outcomes they experience this way. They do talk about it. They will say, the benefit I had of having a lawyer was that I, got to stay in my house. But they spend a lot more time talking about what their actual experience was with the lawyer and how that lawyer made them feel. And so one of the things that I've been looking at is kind of 3 emerging themes, which is one is that they care about caretaking, which is this idea about how we pay attention to people and how they make you feel and what those relationships are. It feeds into a second one, which is about relationships, because a lot of times when they talk about their lawyers, they talk about their lawyers as their family and being treated like family and the importance of that. And then they also talk about community. And I have 3 great slides on the data that we're going to go really fast through because I don't have time to talk about them. But that flesh out these ideas that are coming out of the data. So this is just a former client talking about all of the support that he feels like he gets from legal aid, and how that makes him feel and how that's important to him. A number of things they talk about is relationships. It's what we talk about in Native communities as ken-making, which is where you talk about someone in familiar terms so that you can relate to them. And a lot of clients talk about their lawyers this way. And then the third one has to do with community, in the sense that when it comes to community, these are people that are part of our community and always will be. And I think what this kind of suggests is that when we're thinking about legal effectiveness, we're not just thinking about direct outcomes, but we're also talking about the quality of the relationship with the lawyer, and how that representation works. And I think what this does is it indicates the limits of the current measures, and so it suggests the needs for a different approach. When we're talking about legal effectiveness, it isn't just outcomes, but this quality and things like that. So there are different dimensions that we have to take into account. So what I'm working on right now with the legal aid organization is thinking about how to recraft these. How do you take something like caretaking and make that into a measurement, much less a measurement that a legal aid office has enough time to deal with, and you don't add this kind of administrative burden. So the simple way is actually the second part of the slide, which is thinking about relationships and community, because those can be measured in kind of a linear transactional way. So one way we've thought about this is the example of eviction. You take the client and you think about, they retain their home, they keep their kids, they stay in the community, they get security. You think about what's the effect on the children, they get security, they're not getting moved around. But you see how we're trying to broaden out how you think about those direct impacts. And then I think there actually has to be a second access where you think about those issues of representation and client satisfaction. That we are facing the challenge of working together to collaborate to try and figure out how do you come up with measures that actually work on the ground, so that attorneys who are already really, really busy don't feel like, wow, I've got one more thing to do. And also dealing with the struggle of having a client population that you can give them as many surveys as you want, you're probably not going to get them back. And so those are some of the practical things that we've been dealing with in terms of the collaboration. I want to say that this research could not have happened without the collaboration from the legal aid organization. They have been engaged at a very high level. I've spent hours of time with them in their office, asking them really stupid questions that only researchers with no background in legal aid ask, and they've been very kind and understanding about it. But there's also challenges, I think, to working with practitioners, one of which is that you have to be very aware of their time constraints and experiences, and you have to also think about where your positionality is. So I've had to watch think about where am I, what assumptions am I bringing to this, and what am I actually seeing in the data versus what have we talked about, or making sure that I'm always trying to map out that kind of positionality and things like that I think are part of these types of collaborative relationships. But overall, I think it has been extremely rewarding, and I hope that we will come up with something that is useful to legal aid communities and coming up with better ways to measure legal effectiveness so that they can serve our communities better. Thank you.
Hi, everyone. My name is Neel Sukhatme. I'm a professor and I'm the Associate Dean of Research at Georgetown. So my background is maybe a little bit different than others. I'm a lawyer, but I'm also an economist. Do we have any other economists out in the audience here? Okay, so we got a couple. I think it would be great if economists were more involved in the access to justice field. I feel like I'm coming home. My first job in the law was as an intern at the Legal Assistance Foundation of Chicago. So it's wonderful to be here, and I'm grateful for this opportunity. So I'm going to talk about a little bit of work that I've been doing in Oklahoma, in Tulsa, Oklahoma, trying to measure the impact of legal aid in the eviction context, right? So there's 2.7 million people, I think, is the estimate of people who face the threat of eviction every year. And Tulsa has the 11th highest eviction rate of any city in the country. And a lot of the research that's been done so far has been very kind of East Coast centric, right? It's been focused on Boston or New York. There's some other places, but there haven't been that much work done in smaller cities and more rural kind of environments. And so hopefully this pushes the boundary forward a little bit. That's one area. Secondly, I think the focus oftentimes is on the very direct consequence of providing legal aid, and it's not so much on downstream consequences. You know, being evicted has a lot of impact on people. Does it affect your desire to participate civically after the fact? Does it maybe make you more prone to be part of the criminal legal system? Are there these sorts of downstream impacts that that might happen because of eviction? So we're trying to kind of measure that as well. And so fortunately, what I've been able to do is I'm working with the Oklahoma Policy Institute, which does policy work in Oklahoma, and they're working with Legal Aid Services of Oklahoma on this project. And we have this ability to do this kind of unique experiment in Oklahoma and Tulsa, which I've been part of. And so basically what it is, it's a program where there are 2 zip codes in Tulsa where legal aid is being provided for free to everyone for an 18-month period. Right? That period just ended, so I can't have any analysis of the data yet. It starts in September 2022 and it ended in March 2024. And so the idea is, okay, there's 2 zip codes that are receiving legal aid. Now, if you want to measure causal inference, and my research is largely related to causal inference, measuring whether policies work and trying to find out why. If you want to do that, you always need a control group. Okay, you need to have a control group for which to compare, which didn't receive the treatment. So there are 2 zip codes in Tulsa that received it. So what do you want for a control group? Well, ideally, you want it to be kind of similar to the treatment group, except for the fact that the treatment group had this right to counsel program in place. And so if you look on the map here, it's hard to see. I apologize, it's not a huge screen, but there are 2 zip codes in purple. This is the map of Tulsa. The purple ones are the treatment, and the yellow ones are the control. And there are different methodologies that economists and other quantitative researchers use. One's called difference in differences. I don't know if any of you have heard of that, but that's one technique that's used to measure these sorts of studies. There's also a more fancy one called synthetic control, which I'm happy to talk with you after the fact. Think of it as like a much more advanced version of difference in differences. So basically what you try and do is you find similar zip codes, and you can measure whether outcomes change in the treatment versus the control over time, okay? And so that's what we're doing. And basically, where to point again? There we go. So first thing to check is to make sure that your treatment and controls are kind of similar. You want to make sure that they kind of look similar. So if you look here, this is showing the 3-month average eviction filing rate in the purple versus the yellow. Those are treatment versus control groups. And you can see that they're going in a sort of a similar fashion. There are a lot more tests that we can run, right? They look like they're good controls. So that's a good way of measuring policy right here, okay? There's other ways of measuring. You can look at the top zip codes by eviction judgments. You can see they're at the top right there. Okay. So what are we trying to look at? We want to measure outcomes. Now, they're direct outcomes that everyone cares about. Is the person actually evicted? Also, what's the time to eviction? Because, you know, giving someone a few extra months, that might actually be more important than whether they're actually evicted or not. And so what we're able to do, and hopefully you can read this, we're able to determine whether or not an individual is evicted and what the time is between the filing of the judgment. We can also determine whether the landlord is a corporate landlord or not. A lot of landlords nowadays are kind of own multiple properties or corporate entities. And there's actually a group called the Gold Star landlords. They're supposed to be the good ones. So we can see if there's any difference for them. And then there's a number of other potential outcomes. So what's cool is we're going to be able to measure, hopefully, we think where individuals moved after if they're evicted. And so we can see, hey, when you're evicted, do you move from a zip code that has, you know, a certain level of income to one that has higher or lower income? Are you moving into a worse setting? If we can measure what property they move into, is the property that they move into, is it better or worse than where they were previously? So we're going to be able to answer some sorts of interesting questions related to that. We can also look and see stuff, for example, like misdemeanor prosecution. Did you face a misdemeanor prosecution in a certain period of time afterwards? That sort of thing. Now, there's reasons why, in terms of statistical power, we may not be able to get into all of those things, but we're going to try to look at that. And one important thing, by the way, for legal aid providers, when you're working with a researcher, you want a researcher who's going to be able to state what they're looking at before they actually look at that, okay? In economics, they publish something called a pre-analysis plan. So it basically ties you to what you're going to look at. So after the fact, it's not like you can kind of search for stuff after the fact, after the experiment's done. You have to say, I want to look for X, Y, and Z. So you're kind of tied beforehand. That leads to research credibility, okay? And I'm going to skip over these slides. There's more data on like information about who these individuals are in these cases are. There's complexities in terms of how you define zip codes. I'm going to also skip over that. What I want to do is, and I know we're a little bit behind, so I'm sure you'll be grateful if I finish a few minutes early here. I want to talk a little bit about what it means to work with legal aid providers and also just providers on the ground, right? So I think researchers many times don't have a real sense of the challenges that real world providers face, right? So researchers are focused on research questions, as they should be. But when you're a legal aid provider or you're a provider on the ground of some sort of a service, you have to worry about actual clients. You have to worry about like being able to continue to do the work that you're doing. And so there's sometimes a difference in incentives, right? And there's sometimes a difference in risk appetite. If I'm going to be studying the efficacy of legal aid with a legal aid provider, there's some risk that the study might show that the legal aid is not effective. And that's a real risk that you have to be acknowledged and be cognizant of for the provider. And that might be a reason why a provider may not want to participate. And there are also issues of privacy and attorney-client privilege that researchers are sometimes not as sort of attuned to. So I think the first thing I found is that finding a good partner for these projects is essential. You need to find the right partner, and that means it's a legal aid provider who's committed to the idea of research, really wanting to know the answer to research questions, and a researcher who actually cares and understands and tries to work with the legal aid provider to find win-wins. So I'll give you an example of another field experiment that I ran in a different setting. I'm newer to the access to justice area, so I did more work in the criminal legal system. So I came up with a win-win in the context of jury duty. So I don't know if you know this, but a lot of people, when they're summoned for jury duty, they just completely blow it off. They don't show up. In some cities, it's like 60% of the people just blow it up. I'm not talking about filling in the form saying, oh, I can't go. I'm talking about just not showing up altogether. And that's a big problem. How can it be a jury of your peers if people are just not showing up? And so what I thought about is like maybe what we can do is design an experiment with the jury office that tries to increase response rates for jury summons so people actually show up. Because that's something which jury offices care about. But maybe we can make it into a social science study where we vary the type of summons based on the motivation. So I'll design one summons that appeals to people's patriotism. I'll design another summons that says, hey, you get time off of work, you get compensated if you are if you have to go for jury duty. I do another one that says, did you know that, by the way, if you don't show up for jury duty, that's a crime, right? And you vary that, and you have a control, obviously. You always have a control, and you send it out, and you see what happens in terms of people showing up for jury duty. That's a win-win, because whatever the answer is, the provider there is going to want to know. It helps them. It helps their bottom line. And then the researcher is an interesting research question. So I think sometimes, so if there are legal aid providers out there who are interested in sort of quality of service questions that we can tie into bigger questions about human behavior, about how we can help people who need legal aid, I think those are the kinds of research questions. There's very fruitful opportunities between researchers and legal aid providers to determine, what services work and what might work better, so they can do their jobs, legal aid providers can do their jobs well, and researchers can answer questions that are of importance in the scholarly world. So, what's that? Oh, that again is ongoing. So that is closed actually. So this is in a major American city. So it was pretty cool. And there are actually a lot of cities. Once I framed it this way, there are a lot of cities who are interested in working with me on this. But I picked one, so stay tuned. So, thank you.
Hi. So I understood my role here to respond to the wonderful research that has been presented here today with our practitioners, and also to reflect on my own experience both as a legal aid practitioner of 25 years working with researchers. And so a couple of things I want to say just in thinking about these like amazing projects that are going on. What struck me as I was reading through their abstracts and their presentations today was really this idea that we could move beyond sort of this idea of paper justice, right? So those of us who are legal aid practitioners, we, we're limited in our ability to figure out the effectiveness of the work that we're doing, although we really want to. And one of those things, the way that we have typically measured those things is through whether we're successful in getting a court order, right? And that is, that's justice on paper, but we don't know whether or not that translates into reality, to something that's really going to help people. And all of the folks here on this panel are really working towards figuring out really whether or not our justice system is in paper only, or whether and how it translates into reality. And I really think that that's where the future is of legal aid, right? This is what we're trying to do. And all of, those of us who have been in legal aid for any amount of time, we have always been strapped for resources, and we're doing the best that we can when we have to make decisions about how we will use those resources, right? But we are rationing justice. And when we do that, we're doing it, I can think of a million, and I think I see Cesar here and my other legal aid colleagues, that there are conversations and debates that happen across every legal aid organization for time immemorial. And they are we going to do systemic work? Are we going to do individual work? Which is better? Should we do family law? Should we do debt collection? How are we going to spend our limited resources? And we don't have the information that's needed for us to be making those decisions with the tools that we have. Because most of those are we're making these decisions based on like paper justice, what I would call. And so I think it's really exciting as we think about involving researchers in this space and pairing research with practice, because I do think that legal aid practitioners, we have some sense of things, right? Anybody who's been doing this for some amount of time, you have antidotes that tell you a little bit about whether you're in the right direction, which is a nugget to start with. And so we have important information to share, but when it's married with folks who have the skills and the expertise to move beyond that and think about things like, for instance, I love this idea of, sort of the radiating benefits of the work that's being done that Kirsten talks about, and whether or not it's really important to have the relationship building with the folks that you're serving in the community. I have a sense that that's really important. I think that, and these are just my thoughts, right, that justice and community are really intertwined, and you really can't have one without the other. And so there's something very important that's happening in that space. But it would be good to know. It would be good to know so that we could base our program on something that, makes that happen. I also wonder about, I think, so I guess I want to step back for a second too and talk about, one of the most formative, for folks who've done legal aid work for a long time, particularly in the domestic violence context, one of the base research lines is a Farmer Teffenholler study, which said that legal aid is one of the most effective, in fact, the most effective means of ending a domestic violence situation. That is great information. And with that information, as a legal aid practitioner, I would say we are going to dedicate resources to doing that because we know that it works. But the thing of it is, those are really messy cases that suck up a ton of resources. And so when you do that, you are spending those resources on something that will be like a huge time suck. But if we knew a little bit more about that, like what is it about the legal aid the legal aid that's being provided at that moment, why maybe we could proper dose it, right? Like we could think of it, and maybe it's at a particular time and it's a particular space, and that would help us allocate those resources in a very efficient and effective way and make us more impactful. I also think that, this idea too, when we're talking about radiating benefits, I'm really struck about, if we stop thinking about it beyond just whether or not somebody stays in the house for that amount of time, but also whether the family stays together, whether the community is more secure, has a great amount of potential. And so I think there's just so much power in these partnerships. And I would also just, I guess, one other thing, just skipping back to Margaret's first, her presentation too. When we talk about trying to understand the effectiveness of AI versus human-based, that's really like important to know. I'm also wondering too whether or not when we're if there's the potential to understand not only what frontline practitioners think are important when we're measuring outcomes, but also whether or not the people being served, what are their, what do they find is important? And that would help us redesign our systems. And so I guess those are like the thoughts on that I have regarding the presentations that came today. I also just want to step back and say that in Alaska, we've been really fortunate to be working with researchers on the NSF grant to study the community justice worker program there. And I think that that's been really important too, because out of that research, for those of you who are legal aid practitioners and that you might want to think about whether or not you want to engage with researchers or not, it's been very helpful for us to understand exactly what is the special sauce that is happening here that is, if we're hoping for scalability, what exactly is happening here that's going to make this work in other contexts, and what should we be focusing on? And we've also had like a really good back and forth with our researchers, where they'll come to us and say, like, this is what we're hearing. These are the problems that we're hearing. Why is this happening? And we're able to explain, oh, that's happening because we have this rule, or we have this requirement, or we have this thing that we're challenged that we're trying to address. And that back and forth is really helpful because it helps us rethink policies on our end, and also for the researchers to understand too that there are these additional barriers. It isn't just like the legal aid practitioners don't know what they're doing. It's they're trying to do workarounds of a million other things that have complicated a system. And so I think it's really helpful. And I wish, I guess, when I had started my journey in legal aid, that I had the benefit of having sort of an evidence-led practice to begin with. And I, would hope that those of us who continue to do this work, that maybe we could think about sending out the next generation of legal aid in a way such that we're working hand in hand with practitioners to try to get the job done in a way that really makes sense and understands what we're doing beyond just trying to achieve a paper order that says that justice was achieved. And what we're really looking at is making sure that that translates into reality, into the world.
Great. Thank you. So we now have about 20 minutes for questions. So Elizabeth's going to grab the mic and we'll just go around the room. I guess I wanted to start with a question. And we've painted a fairly rosy picture of research and partnerships. But the fact is, all of the panelists here are professors in law schools, and doing empirical research, which is somewhat unusual. And I think within the civil legal aid tradition, there's not a strong tradition of evidence-based practice, as Nikole has suggested. And a lot of the evaluation that happens by consultants or firms. That data doesn't get shared. There are lots of challenges to these partnerships. And so I'm wondering if each of you could go around and speak to what you think one of the biggest challenges is, and how you think we might overcome that.
All right. So first, actually, before I even do that, I want to acknowledge on this project, I should have mentioned their names. Anthony Flores and Branson Gregory at Oklahoma Policy Institute are amazing. And my former PhD student, Alexander Billy, is working on it too. So what are challenges? I mean, there are a lot of challenges. I sort of hinted at one of them, issues related to attorney-client privilege and privacy. I think that's something which we need to come up with better systems to ensure that, first of all, do no harm, right? We don't want to hurt the people we're trying to help. Everyone here is trying to help these individuals, regardless of what the perspective is as a researcher or as a legal aid provider. I don't have any great answers, but I think that issue is an important one. And I think that kills a lot of research projects before they can get off the ground. And unfortunately, if you don't have the research as to what works best, then you can't design systems that work best to help these individuals. So even though it might help one individual in the abstract to be like, okay, your privacy rights are there, legal, you know, you protected the privilege. As a whole, as a society, as a system, we suffer when we don't have good information because we can't do these studies. So I don't have a good answer, but I just wanted to highlight that as a problem that we all need to be thinking about creative solutions to.
Well, sort of backing up one level, I think a lot of the work that I'm doing is built on the court record data research that I started with. And so I would say access to court record data and disaggregated case management systems in state courts is one of the initial challenges. A lot of legal aid programs don't know what's going on in their jurisdictions because that data is hidden by, you know, third-party vendors that are hired by the particular county courts. And so it's difficult to sort of see a picture of who's being served, what are those case outcomes. And so legal aid partners are only able to see what happens within their own case management system, and those are the people who find them for help. So in designing this project, I'm working to try and bridge that gap. But I would say access to data and court record data is definitely a huge challenge. Another challenge is, as I'm trying to study people who don't seek help, right? Trying to encourage people to come talk to us when they didn't seek out help from a lawyer in the first place is a little bit challenging. One of the ways that we're trying to work on that is that the recruitment letters that we send out do say that, you know, we can potentially provide, well, not a referral, but provide some information about legal services that are available. So when we, at the end of the interviews, we are providing information and a flyer for the legal aid programs. So if people have a default judgment, for example, and they're within the time to get it to set aside, we're actually providing that information in real time to our study participants. So in addition to like a $20 gift card, we're also providing information for how people can obtain assistance with the actual thing that we're studying. So those are both a couple of challenges and at least one way we're trying to get around it.
I would say ongoing capacity in the institution. I've been parts of projects where maybe there's a mayor or a chief justice or another court administrator who's very excited about research, sees the alignment. They might move on in a year or two, and research takes time. Also, I think, especially working with courts, oftentimes there's no one in charge of strategy, of user experience, of measuring outcomes. And when you don't have a staff person who is dedicated to understanding what actually happens to people's lives, are we making a difference or not, it's hard to kind of force that upon them to get their data person talking to their clerks, talking to their administrators. So there's just not that kind of institutional capacity. It could exist. Hopefully staffing and timing and other things can change.
I just want to add, I don't think that's limited to just courts. When you first started talking, I thought you were going to talk about institutional capacity in a different way, but I think there's also a challenge of realizing, especially with practitioners, they are busy, they are overcommitted, they have way more people coming in the door than they can possibly serve. And how do you be mindful of those are the constraints of the situation, and try and be efficient, both in coming up with how to do things better, but also in mindful of, oh, you can spend an hour and a half talking to me, or you could be working with a client right now. What is the better use of your time? I hope everyone thinks there's an obvious answer there. I think Neel raises a really big issue about confidentiality. The population that I work with, these communities have a high level of intergenerational trauma, which is something I think a lot of legal aid workers and frontline justice workers are familiar with, is dealing with people that have histories of trauma, but having to constantly think about how to be not just protect their confidentiality, because these are also very small communities. I have lots of conversations with people about, and and this is a community that I have a long history in and relationships with outside of this, but a long discussion about how I understand what it's like when you live here, and I am not interested in sharing your business with everybody else in the community. I'm fully aware of how gossip works around here. I don't want to be a part of it. But also dealing with asking people to relive a part of their life that was not particularly pleasant. And so being informed about how to proceed with caution and care and dignity, in addition to just the confidentiality issues.
Questions in the audience? Way in the back. Gonna make Elizabeth work.
There it is. Eduardo Gonzalez, American Academy of Arts and Sciences. My question is maybe to see where you all as researchers and practitioners working here could help us think about what could be legal empowerment metrics. So part of, the context of communities is that they may not even know what justice should look like. And so when they're giving their lived experience of how it could look like, it might be limited because they've been so disempowered and deficit focused. So if we think about this, based on the sort of research that your cohort has sort of illuminated, what could potentially be an empowerment metric that we can begin to measure as sort of an output of these interactions? Like somebody is actually willing to go back to the legal services, so they revisit the legal aid after the issue. That could be a good metric. And I wonder what your all thoughts are on how, or what hypothesis we could begin using to figure what that is.
Well, this came up, so before I had done the research with the frontline providers I talked about today, I had done an earlier study from July to October where I was interviewing litigants in the courthouse lobby and people who I had recruited online to give them a fictional situation, present them with AI tool, see how they asked it questions, and evaluate what it responded. And this notion of empowerment as in that kind of brief advice interaction came up regularly with the litigants. The main way that they would phrase it is, this tool either makes me want to keep going or this is too much. And we see that when we evaluate other kinds of legal aid services, websites, or tools. Does this kind of close a person off from pursuing their rights or feeling like they belong in the system or they can handle it? Or does this thing, whether it's giving advice, a flyer, a website, make them want to keep going? So as we're thinking about auditing the AI platforms, and I think the frontline providers who we interviewed also mentioned this, that how the kind of next steps plan or the list of the rights or the list of the law, the phrasing of it, the level of detail, all of these things might figure into that outcome of someone keep going or close off and say, this isn't for me. So we had to think about particularly how we'll evaluate that like on its face without seeing necessarily how people actually act after they talk to ChatGPT, but hopefully we'll be able to find some ways to measure that on its face.
I don't think I have too much to that, but I guess it depends on what you define as empowerment, right? I kind of view it as there's actions and then there's sort of beliefs and like a feeling that you have. Like to the extent that an intervention increases a justified confidence in one's ability to control their legal fate, right? If we kind of view that as one element of empowerment, then I think survey evidence might be a good way at getting at, okay, how do people feel about the legal system? How did they, what kind of knowledge did they have before the intervention? And now how do they feel about it and what kind of knowledge do they have? And you could sort of see if it's justified based on the accuracy of what they know and how they feel about it. So that might be one idea, is this might be a place where surveys are really potentially useful.
I'm just going to say the survey depends on the community. working with a community that is notorious for ignoring surveys. But I think one way to think about it is also to start thinking about what are the metrics of disempowerment, which seems a little bit backwards, but I think that's where a lot of what I hear about is how disempowering the legal system is. Now, the majority of people I talk to are people who, like the people that Claire is interested in, get hailed into a legal system, and it's not by choice. And they find it extremely disempowering. So I think I could tell you a lot about how to measure disempowerment at this point, but I haven't gotten far enough to be able to tell you what would be empowering. I think there's also something else really important that you said about maybe they don't even know what justice should look like. And that's a question I ask people. And I think the answers are going to be complex, and they could be very nuanced by community. And so we probably need to start thinking more broadly about what do we mean and what do people mean by that, because what's going to make people feel empowered is going to have a lot to do with what they think justice is. And I know for some of the people I talk to, justice doesn't have anything to do with the law, which means empowerment might not have anything to do with the law, which is an interesting but very different way of thinking about it, at least for me coming out of a law school.
Well, I think that also points to the complexity of the systems that people find themselves in the legal system. These are legal systems designed for people with lawyers. And when we talk about trying to solve or design unbundled services and solutions that empower people, with a nod to the Harvard Access to Justice Lab's Financial Distress Relief Project, which has been doing a randomized control study on this for the last decade. When we look at trying to solve problems from the bottom up, trying to design around really unnecessarily complex systems, I think it also begs the question for us as access to justice reformers that, what are our conversations with the courts looking like about reform of the courts themselves, right? I would look at Bonnie Happier and the Family Justice Facilitators project that happened in California, putting people in the courtrooms and in the courthouses that were designed to work with the vast number of unrepresented litigants in family law cases, made a huge difference in the substantive outcomes, but also the way that people could manage those processes, in part by simplifying the processes themselves and providing people available in the courtroom to help people navigate those processes. So that was a twofold process, both empowering the people to navigate the system, but also simplifying the system itself. So
all I would say is that I think at the heart of it is sort of where Margaret is going, which is this for me, right? Is this, and how we measure that is whether or not people feel that there's a sense of belonging and engagement within these systems. And so figuring out a way to answer that.
One more question, I think.
Just to comment on that, Eduardo, Emily Labrada in New York has done a lot of work around procedural fairness, client perception, how they were treated, to make an enormous difference in whether they felt that they were effectively suited and achieve what they wanted to do. So it fits in very well with what Kirsten was.
Great. Struggling not to come in here. I think we had, there's a great literature on procedural fairness. There's also an emerging literature on legal capability, particularly within the work of the Victoria Law Foundation and in the UK. So Pascal Pleasance, Nigel Palmer, Becky's been involved in some of that work as well, which is looking more at legal experience or experience of the law as opposed to experience of empowerment around a specific intervention. I think I saw two hands go up at the same time in the back, so I'm going to give you a chance as well to come in. And we've just got about 3 more minutes, so we'll try to make it quick.
Jennifer Lechner, North Carolina Equal Access to Justice Commission. You've talked a little bit about the challenges in your partnerships. I'm wondering what you look for in good partners, and how do you identify practitioners with whom to work?
So I'm happy to kick that off. I think that commitment to the project for a period of time, I think is important. I think Neel spoke about that previously. And also sort of commitment to creativity, to thinking outside the box, and to sort of seeing what comes out of the research.
I agree with those. I also think there has to be a certain amount of flexibility because projects change over time, and a willingness to collaborate, particularly when you have a really high level of interaction. So it really takes a commitment, but that commitment has to be fairly broad and deep.
Yeah, I agree with all of that. I mean, I think to some extent when it gets hard, you need excitement. So you need people who are really interested and sort of curious about the question, really want to know the answer. And I think that drives it forward through the hard times.
Well, I would say there's like a light version of partnership where as long as you're willing to come to some meetings and share your data, let's partner. But the deeper one, I would say it's about people-centeredness, that there is a leader or a champion who says no matter what the data says, we are going to use it to make this system better for the users, for the advocates, for our frontline staff, but we have a commitment to make this system more people-centered. And no matter what the research says, this will be a benefit to that bigger mission.
We can do one more quick question. Yes.
Good morning and thank you. I am Nikole. I wanted to ask, you mentioned about the vast studies that domestic violence and legal aid has been high in numbers. Has that research shown any implementation across the board, or where could I find that? Being an advocate for 33 years, I really want to find out how can we help and utilize that research information? Where should we look?
Yeah. So the Farmer Teffenholler study, I think that's from 1998, is that right? Right. So it's been around for a long time. I can share it with you. And I think there's been some updated studies around domestic violence intervention too that I think I would rely on my researcher colleagues to share. But again, it's, sort of the Farmer Teffenholler study was a seminal study that essentially said, like, giving survivors of domestic violence a legal aid attorney was one of the most effective things in helping them break the cycle of abuse. So.
As I remember that study, it was getting restraining.
Okay.
Not necessarily having an attorney.
I think it was an attorney. It was an attorney, yeah.
Great. So that we're out of time. We're going to take a 15-minute break, but before we do that, let's give our panelists a round of applause. And see you in 15 minutes.
Civil and criminal law. I'm Robin Bartram. I'm a sociologist and a professor at the University of Chicago. And it's a real pleasure to moderate this session and introduce you to people whose work I really love and admire. So, first of all, we will be hearing from Brittany Friedman, who is at the University of Southern California. Then we'll hear from Sarah Lageson, who is at Rutgers, Karen Martin, who is at the University of Washington, and Maureen Waller, who is at Cornell. And then last but not least, we will be hearing from Ed Wunsch, who is at Legal Aid Services of Oklahoma. So I guess without further ado, I'll hand it over to Brittany.
Okay. Oh, yep. I can. I'm up close to the mic, but let me know if you can't hear me. I'm going to do my best to project without causing a sound storm, because the louder you get up here, it's quite loud. Okay, great. So thank you, everyone. Thank you very much for being here. I very much appreciate this invitation. It's always great to be in this group. And as Robin said, my name is Brittany Friedman. I am an assistant professor of sociology at the University of Southern California. And I'm also the co-founder of the Captive Money Lab with Doctors April Fernandez and Gabriella Kirk-Werner. Great. Okay. So given our country is the largest incarcerator in the world and disproportionately entraps low income and communities of color, we ask an important question, And many scholars are asking this question, right? Who pays for the exponential ballooning of justice institutions? And so according to a 2017 prison policy investigation, the system of mass incarceration costs the government and system-ensnared individuals and their families at least $182 billion annually. Our research and that of our colleagues who are working in this area has shown that as correctional populations began to rise, due to tough on crime policies and the war on drugs, states were simultaneously experiencing fiscal crises impacting all social institutions of the 1980s. And so to cut costs, states began to expand their use of what are known as monetary sanctions. Monetary sanctions, for those of you that don't know, are legal financial obligations and include fines, fees, restitution, interest, surcharges, assessments, and other costs that are imposed for a myriad of offenses. And so this can range from traffic violations and misdemeanors to all felonies, and also include potential costs for time spent in jail and or prison. And so it is the same communities that are overrepresented in terms of incarceration that are saddled with this financial debt that they now owe from monetary sanctions. This is because the pervasive use of monetary sanctions has resulted in shifting the financial burden away from the state and departments of corrections and taxpayers. And so this cost shifting can be most acutely seen in the use of pay-to-stay practices, with system-linked individuals being charged for the cost of being detained in jail or incarcerated in prison, effectively creating what we would consider to be a captive market. And so cities, counties, and states significantly increased their reliance on pay-to-stay and expanded the practice of holding incarcerated people responsible as the consumers, and I'm using state language, consumers of daily life necessities. And so this means charging them for specific costs such as telephone calls, email, commissary, medical care, reentry focused classes, and also per diems for room and board costs that are at a daily rate. And so the focus of my talk today is on pay to stay at the prison level, and specifically the practice of charging daily rates or per diems, and then following up by enlisting the Attorney General of that state to sue incarcerated defendants in civil court without the right to an attorney, because it's a civil matter to seek payment. So pay to stay is particularly complicated for incarcerated defendants because of legal hybridity, meaning that prison pay to stay exists at the intersection of criminal, civil, and administrative law. And so even though people are receiving a bill for their time served in prison as a result of criminal contact, the matter is now settled in civil court, which creates a whole host of complications. And so for the past 6 years, we have been researching prison pay to stay in a few states. And then up until this last year, we were able to consolidate our efforts based upon support from the American Bar Foundation, the JPB Foundation, Access to Justice Scholars Program, and Arnold Ventures to found Captive Money Lab. And this year we kicked off a 50-year state national survey of pay to stay to actually figure out, do states have these laws on the books? Does every state have the law on the book? And we found so far that at least 43 states have this law on the books in terms of at the prison level. But are they actually using that? And so our team is now trying to figure out, are they even enforcing the law? Because we've had certain states respond to our FOIA request, for example, like North Carolina, and they're like, yeah, we have that law, but we're not really like interested in it. Whereas other states, as I'll talk about, even Michigan here is very interested in it. So this, our site will be continually updated with our latest findings and research outputs. So what have we learned over the last several years of studying prison pay to stay? So we've learned first and foremost, and I realize you may not be able to see this timeline, but definitely email me for my slides.
that fiscal crises such as the 1980s recession and resulting austerity in terms of public governance, in part, definitely spurred the adoption of pay-to-stay policies. So we see a huge adoption rate happening in the early 80s and then again in the 90s, and then also an expansion of pay-to-stay laws. And so we've also found that states pretty explicitly frame incarceration as a public commodity, meaning that it is considered, lawmakers are considering it in our analysis of their debates over the matter. Incarceration is a public good funded by public money, such as taxpayer dollars, and incarcerated defendants are thereby unjustly consuming this good by their very incarceration and are liable for reimbursement. And so you'll see on the slide, this is an example of the types of bills that we get in our completed FOIA requests. And so this is an example from the state of Illinois. But, for example, Michigan, I could have put a Michigan one on the slide. They look very similar, and it shows the daily rate that is calculated. Sometimes it's quite arbitrary. Other times they try to make it seem like it makes sense. But I can tell you that, honestly, a lot of the making it make sense is done in a rush in terms of making it look good for the court. That would be my opinion so far based off of our research. Another key thing that we have found is that surveillance, such as monitoring mail for any notifications of benefits, insurance payouts, or monitoring inmate accounts for any sign of regular deposits, to the forced disclosure of assets, which you can see on the slide, is a way that people are routinely required to kind of unveil any assets that they might have. And so this example is from a lawsuit, and it's an exhibit from one of our FOIA lawsuits, which is showing that the court presented this stating that when this person was admitted, they are forced to fill out this form upon penalty of denied parole, possibly if they lie or if they omit anything, and they have to list, if you could see it, you would see they have to list everything. So everything ranging from this person lists a property that they have to list anything in their external bank accounts, veterans compensation, retirement benefits, so anything monetary they have to list. And it doesn't really matter if it's jointly held, and that's a big issue that we've seen of people pushing back, is that the assets will be held with partners or it will be used to pay a child's tuition, but this does not convince the court actually in terms of judgments. Also, we found it's very important that even tiny amounts, and tiny is relative, but the tiny amounts of money can trigger a six-figure lawsuit. And so on this slide is an example of another exhibit, which is used as evidence against a person to show that their loved one was depositing about $200 deposits routinely. And so those $200 deposits were enough to have their account flagged and referred to the accounting department for the Department of Corrections, which then sends it to the Attorney General of Illinois, who then files a civil suit, which freezes their assets and prevents them from hiring an attorney, but then also allows them to do a forensic accounting of everything that they're worth to see if they can actually pay the six-figure suit, which routinely they cannot. But this just kind of gives you a glimpse into the process of what we see in our case files. So for the rest of my talk, I will conclude with our most recent analysis of bipartisan advocacy around reforming the policy of pay-to-stay, which is starting to gain a bit of steam around the country, but there's still a long way to go. And so for this talk, I will draw from our analysis of what happened in Illinois to shed light on the nature of this current moment and possibility for reform. And so obtained predominantly through FOIA and also public record searches, for the state of Illinois, our data set currently includes copies of state-level pay-to-stay statutes. We have transcripts of legislative debates on the adoption and revision of these statutes over a period of 4 decades. And so for Illinois, the law was established in 1981.
And we have 103 civil lawsuit complaints that were filed by the Illinois Attorney General's office between 1997 and 2015. That's what they were able to give us, seeking to recoup pay-to-stay fees. And so our case files are pretty extensive because they include not only the initial complaint, but also the transcripts, exhibits, and rulings. And just to note that for a comparable time frame for Illinois, for Michigan, we actually received over 1,400 lawsuits rather than 103, which gives you a sense of the variation that our lab is currently trying to understand, because there's definitely states that we would consider to be heavy users of the law, and Michigan is one. And so our analysis for Illinois is quite telling, especially as we start to look at other areas that are considering reform, that have done partial reform, and as we work with our community partners, meaning ranging from private attorneys that have reached out to us about litigation strategies, to legal aid groups, to public justice organizations that are very interested in creative ways of tackling this issue. So our analysis of Illinois revealed that lawmakers in Illinois who were considering reform in 2016 and in 2019, in terms of repealing prison pay-to-stay statutes, what happened is they actually made very similar arguments that were used to pass the initial law, which we found fascinating. So when the law was passed in 1981, lawmakers argued we need to protect taxpayers, we need to be more fiscally efficient, and we need to address rehabilitation. And the way we're going to do that is rehabilitation. It's going to be teaching people the meaning of money by actually charging them and forcing them to pay it back. Fiscal efficiency in terms of we're going to shift the cost away from taxpayers. And so that becomes very important. And I'm going to kind of skip ahead so I can make sure, okay. I can maybe get to one of the quotes. Okay. So I will skip over this because in the interest of time, but essentially these quotes are making clear the point I'm making is that lawmakers very much repurposed similar logics in terms of why they should initially pass the law in 1981. And then when it comes up for debate in 2016, what happens is that the state of Illinois essentially gets publicly shamed by the Chicago Tribune. And we get asked a lot of questions in terms of why is Illinois, why do they even have this on their radar? Why does it become important? Well, it actually shows in terms of organizing strategies that having an expose in the Chicago Tribune that really put this issue to the forefront of the everyday person in Illinois was huge, because prior to that there was some groundswell, but there wasn't a lot in terms of organizing around this issue. And basically what the Chicago Tribune does is they do an expose of a person who was sued in this manner, who essentially once they're released dies destitute, and their family doesn't even have enough money to bury them. And there's a lot of lawmakers that get behind this. It gets bipartisan support. It goes up for a vote in 2016, and it actually passes, but it ends up getting vetoed by Governor Rauner. And when he vetoes it, he creates, in my opinion, based on our research, he creates a lot of enemies, but he ends up vetoing it because he says, well, we need this law to hold people accountable. And he starts talking about John Wayne Gacy and a bunch of different very sensationalized cases that we see routinely used to actually bring about mass incarceration. And so the bill basically dies. But in 2019, we see a resurgence as soon as he is booted out of office and Pritzker's in office. A very similar, just exactly the same bill just goes through again, passes. And it's lauded as a huge success because it fully repealed prison pay to stay in Illinois, even though it's not retroactive, which is something I could definitely talk about in Q&A. But I think I'm at time, right, Becky? Okay, so I'm at time. I don't want to take away time from my colleagues, but I'm happy to answer more and definitely happy if there's any, Michigan specific questions as we are currently investigating the best way to tackle, I think, the state that we would consider to be scoring the lowest on our meter right now in terms of who's using the law and using it in a way that's creating a lot of harm. So thank you.
Good afternoon. Thanks so much for the invitation to be here. Thanks, Elizabeth and Matthew and Becky and JPB and ABF. My name's Sarah Lageson. I am coming from Rutgers University, and the civil criminal nexus I'm going to talk about today is in the background screening industry. And background screening gives us this fascinating case where data that are created because somebody had an interaction with a police officer or the criminal courts, and a record was produced, that entire discretionary, often unequal, sometimes very harmful interaction turns into this document that can bar your access to housing, to employment, that can show up for a simple Google search of your name. And so we have this moment where you see these two legal systems come together. The other part of the nexus is that this criminal record data, once it becomes a background check, is governed by a totally different set of consumer law. So the Fair Credit Reporting Act is what comes into play if you want to challenge or access the data that's in your background check. And then when these background checks are put into everyday use, we see discrimination law, housing law, labor laws, and informational privacy laws all implicated as well. These checks are ubiquitous, so somewhere between 90 to 94% of employers and landlords are just using background check companies all the time. Market research shows that most landlords and employers don't want to deal with the state to get the records directly from them. It takes a lot of time, it can be more costly, so they rely on private companies. And these companies do a ton of business, so First Advantage, Sterling, and HireRight are producing 56 million checks a year. Checker is the company that most of the gig economy companies use, and they're producing 23 reports per minute. And so a lot of these companies in prior years have marketed the volume of data that they're able to aggregate and resell to these people or these entities that order background checks, which actually tells us a lot more about how many criminal records exist. It's really a mass criminalization story, but this has really been their market strategy to say we have so much data on people. This is why you should trust us to do your background checking. In the past couple of years, there's also been a switch to algorithmic and AI. Algorithmic means as a way to efficiently produce background checks in a quicker manner, to aggregate data across jurisdictions, and to take the human discretion that these companies say is actually harmful out of the picture. So this is a screenshot of from a company called Resident Verify. It's a tenant screening company. And the red circle that says fail is the thing you should be paying attention to here. So instead of getting a report about a person that has the sources of information or the types of information, now a landlord just gets a green circle or a red circle, and they can use that as a shortcut to make this determination. But this raises an empirical question of what is the underlying data here? And if I'm the subject of this report, what access do I have to this information? Can I challenge it? And so for our team, this really became an empirical question that we could answer. So I'll share some results from the study, and then I will close by offering some solutions for what I think we can do about this. So what we did was it recruited 101 people from New Jersey who collectively had about 1,300 criminal charges filed against them in the state at any point in their life. And we enrolled everyone in the study. We had them paid the state of New Jersey to have them get fingerprinted and get a copy of their rap sheet from the state police. So that had everything on it that was ever recorded by any police department or criminal court in the state. We kind of had to make a decision that would be the baseline or the kind of the standard from which we would create this person's record. Then we ordered background checks from a consumer reporting agency that complies with the Fair Credit Reporting Act. So if you are an employer that's going to make an adverse hiring decision, this is the kind of company that you would have to use to protect yourself from liability. And then we ran their names through a people search website. So, when you Google yourself and there's all these companies that are pay $20 and learn more. These companies affirmatively opt out of the Fair Credit Reporting Act. They tell you You can order this report for your own curiosity, but you can't use this to make an employment decision. Of course, we don't really know what kind of decisions are being made on these reports. So we have this comparative angle where we have the estate report, we've got this federally regulated or compliant report, we have this unregulated report, and then I interviewed everybody in the study and we walked through their records. And so their recollection and their memory is also a data source. So we found a lot of problems with the data. So across the sources, about 50 to 60% of our participants had a false positive error, which means something showed up on their record that does not on their private sector record that did not exist on their state record. So this is just stuff that makes no sense. And I'll show you some examples where, you know, I might have 2 convictions on my record, but like 5 different convictions are showing up in the private sector. And then nearly everybody had a false negative. And this is where it gets a little tricky, right? So the state report said this person was, you know, fingerprint based. These are biometric records, fingerprint based arrest. We have a criminal court disposition, and the background check company totally missed it. What does that tell us? It tells us that the whole enterprise is built on a pretty shaky foundation, right? And that if employers and landlords think they're getting this great service for the money they're spending, they're not. The next thing we did is we looked at the overlap between these systems across these sources, and this is like our Venn diagram of the 1,300 criminal charges, and that gray sector in the middle shows where there's a match across the sources. So only 199 criminal charges showed up accurately across these 3 data sources. Another way to look at this, kind of the degree to which there was the matching, is these are our 3 sources here. The state reports on top and the 2 private companies are on the bottom, and where those black dots line up, those are the matches. And then over on the side there, it's what we refer to them as orphan records. These are those false positives that just show up on these private sector reports, but we don't have any way to trace them back to the state. And there's a lot of them, as you can see. And we also wanted to see, well, is there kind of a pattern by which people who just have really extensive records are seeing more error, and people who have minor records are seeing minor error? So this is every participant in our study. And it's a little hard to see, but I can share the slides. And it's sorted by, on the blue column, people who have the most records, and those are charges and convictions are the two colors there. And you can see there's just variation across the sources. So people with, you know, even a minor record by the state might have an extensive record in these private sectors. So it's kind of a mess in terms of what a person's expectation of inaccuracy might be. I'll walk you through 2 of the kind of qualitative examples. So Alfred was someone in our study who had 2 convictions from a long time ago. And this is a screenshot here of his state report from the New Jersey State Police. And as you can see, it looks like it came out of a typewriter, and it has the arrest and then the charge and then the final case disposition. So we have 1986, 1991, 2 drug-related convictions. He also had on there 2 arrests from 1987 and 1990 that were showing up as pending court on the government record. And this really became a problem for Alfred when he tried to file for an expungement, because the court rejected his expungement petition because you can't have pending cases. Those are obviously pending he doesn't have a warrant out from 1987. He had been on probation and successfully completed it years after that. But this was this major roadblock he was having just with his governmental source of the record. So even though we use like governmental sources, like kind of our baseline data, it contains its own internal errors. He also just had enormous trouble getting a job, and he couldn't figure out, you know, these are, sure, I have these convictions, but they're from so long ago. I'm eligible for expungement. I'm trying to go through the expungement process. That's because when you ran his name through the private sector, a huge number of charges and convictions showed up. You can't read them. The font is small because there were so many to report, but there's arson, there's attempted murder, there's child sexual conduct. There's all sorts of really, really serious charges, robbery, burglary, that were showing up on a regulated background check, a background check company that's complying with accuracy standards under the federal law. And it took an enormous amount of work with our legal aid partner to figure out what was going on here. So we ended up getting to the bottom of it. What happened was Alfred had used an alias at some point when he was arrested in the 1980s. Another person in New Jersey in the 90s and early 2000s used the same alias. The court linked their files within its own case management system. When the court sold that data to a data broker, or to a background check company directly, all of those data were merged. So everything that was connected to your alias became connected to your legal identity. So this is just one example of kind of how things can go sideways based on these data problems. And then his story really illustrates for us kind of these major themes that came out across the interviews. And the first is of incorrect data and function creep. So one thing we were learning about this nexus of civil and criminal justice is that criminal justice data is created at its source to do administrative work, right? To manage who's been arrested, to manage a court docket. It just so happens these are also public records. So then they're swept up and they're transformed into these different types of information, far beyond what they're intended use for. So a court is not creating a record thinking that an employer is going to use that to make an assessment about somebody's hireability or their trustworthiness at work. Right? They're creating that data to run the court. So we have this problem of function creep that is exacerbated by the fact that these are technically and legally public records, that they can be scraped, that they can be FOIA, they can be purchased from many jurisdictions. The second is that it's misrepresentative. So Alfred said, look, these things, these arrests, they exist on my record, but a lot of that just has to do with what I look like and where I grew up. He's a Black man living in Newark. He's a young man in the 1980s. And he said, I was an only child. I hung out with my friends. I was exposed to police all the time. Of course, everybody's going to have some sort of arrest record, but that doesn't have any bearing on the ability for me to be a Lyft driver now. And then finally, this fact that it's unknowable data, that this is information that's about you. It's crucial for how you're going to navigate the world and be received by the world. It structures access to all sorts of opportunities and social relationships and family relationships. And yet you can't even get access to what it is. So if you couldn't access your credit report or your health record or your transcript from college, right, you feel it would be problematic, right? Or if you have to pay for that access. And so for Alfred's case, we paid for access to all 3 sources of his record. He had never seen it before. He has the rights under the Fair Credit Reporting Act to get that information, but most of the time the employer is not even going to get to the stage where he's getting access to that report. And I'll close with Lenny, who was in our study because he had, oh my gosh, he had 2 arrests that never led to a conviction. They were just, these charges were dismissed, and it happened he had a roommate in New Jersey. They got in a fight. He went back to the apartment to get some of the stuff out of the house, and the roommate called the police and said, I have a restraining order against him and he's stealing things. There was no restraining order and he did not steal anything. So by the time Lenny went to court, everything was dismissed. But he has these 2 arrests, and he really wanted to have these arrests expunged. So at the time in New Jersey, there was no automatic expungement. You had to file a petition even for non-convictions. So he goes through this whole process. And as a research participant, we pulled his records. He had a case pending for a felony that showed up on the CRA, which, is upsetting because this is not a pending case. It's been dismissed. But when the CRA grabbed that data, the case was still in process. So now it lives on years later as a pending case. And then on the People Search website, nothing showed up at all. So they just happened to not scrape the data around that time. So it created this kind of strange mismatch, neither of which matched reality. Lenny got an expungement, and it was a good day when he got the letter from the state police. He came to the office to show me, and he was like, can I use the copy machine? I have to make like hundreds of copies of this expungement order. And that was because the legal aid provider who had helped him gave him this printout of all the companies he needed to serve this order to get them to comply to the expungement. And he said, look, I have a disability. I'm broke as hell. I'm going to have to send this to all these people. This is confusing to me. I don't even own a computer. And he said, it's depressing. So it was this day in which, this good thing had happened. He got this letter from the state police saying your record is cleared. And you realized the work was just really starting for him. And then he also went and Googled himself, and after a couple of years of this stuff not showing up online, his mugshot showed up on a website that had recently accessed those public records and reposted them. And he said he just cried, that it was this really disappointing and devastating outcome for this one incident that happened with the roommate that turned into a criminal justice interaction, and now is this big kind of privacy violation he's contending with. And most people in the study, there's many, many quotes that I can share here, don't want to engage in this process at all. So this leads to total avoidance of having to deal with this nexus, this big mess of the criminal record itself, and then the companies in the private sector that are using it and profiting off of it. So most people don't look for their record. They avoid situations in which a background check is going to be conducted because they know that to navigate their rights in that context is not only frustrating, but can be nearly impossible. So there's some things we can talk about in the Q&A that are happening. But I will say, what we're learning in this study is there's attention being paid by the FTC and the CFPB. There's new rulemaking around expunged records or incorrect records as being a willful violation of the Fair Credit Reporting Act if a company is going to report those. So there's more attention being paid to it. But I think as at a law school and in legal aid, I think this shows that there's a great opportunity to be bridging criminal legal aid, people that are working on the expungements, with consumer protection, and thinking, bringing students especially into both of these worlds at the same time shows how a solution we might come up with can exist in a silo when we need to be thinking, if you want to be working criminal defense or in criminal legal aid, probably the last thing you're thinking you're going to learn is the Fair Credit Reporting Act. But this is where the help is really needed the most. So thank you very much for listening. Thanks for being here.
Hi, everyone. My name is Maureen Waller. I'm a professor in the public policy and sociology at Cornell University. And I'm going to be talking about economic and racial disparities in driver's license suspensions and how this is linked to the criminal legal system. So, so by way of background, so driver's license suspensions were traditionally issued for unsafe driving. But in recent decades, all states have passed laws requiring or allowing suspensions for non-safety reasons. For example, failure to pay a ticket, to appear in court, to carry insurance, to pay child support. As Brittany laid out very well, I'm looking at this issue as part of a larger system of fines and fees that are being used to fund local and state government, often at the expense of economically and racially marginalized communities. So recently, just in the past 5 years, 25 states, including New York, have passed reforms to limit suspensions for unpaid traffic fines. These are largely out of concerns that this is like punishing drivers who are the least able to pay. So, although this has been, a focus really of a national reform movement now, there's been really surprisingly little data to look at how these new types of non-safety suspensions are related to economic and racial disparities, in part because there's only a handful of states that collect this information on both how many suspensions they're issuing and the reasons for the suspension. We also haven't looked at the potential of different reform options that are being considered, or really the lived experience of having a suspended license, even though this has been identified as a critical access to justice concern. So we're just, starting to trying to get a handle on this issue. So we are able to obtain data from one state, New York, where we got information on all the suspension records that are being issued. And we're also interviewing drivers who have had a suspended license in New York. So, this way. Okay, so I'm going to tell you what's going on and what we're learning so far. So our questions that I'm going to be talking about today are what we're learning about the most common reasons for driver's license suspension in New York, whether rates of suspensions for these new non-safety reasons are higher in economically and racially marginalized communities, how reforms would be expected to reduce these disparities, and then key points of intersection with the criminal legal system. Okay, so right now I'm summarizing. Yeah, I think this is correct. Thank you for waving. I'm summarizing results of a paper actually that was just published last week, and it's in an open access journal. So I put the link here. So you are very welcome to download this if you want to read more. This is a paper with my colleague Peter Rich at Cornell and a graduate student, Nathan Robbins. So again, we're using data on all driver's license suspensions in New York that were obtained through a Freedom of Information request. And then we're merging this with census data at the zip code level so we see which communities are most impacted. So this is information from before the reforms were passed. And the next stage we're going to look at after the reforms were passed. Over here again. I keep forgetting. Sorry. Okay, so what are we learning about most common reasons for driver's license suspension? And this was in 2017 before this recent reform was passed. Okay, one thing to note is that there's a lot of suspensions. In New York, there were over 1 million new suspensions issued in 2017 alone. We got the list of all these suspensions. There were, from the DMV records, there were 230 different reasons just that year listed for suspension. And so we went through all of these and recoded them into 7 categories. So what you can see on the table is that only about 6% were related to driving safety infractions. So for example, like a DWI. The overwhelming were for what we're calling non-payment or non-compliance suspensions. So this includes, there were 22% for failure to pay a traffic ticket, 8% for failure to pay the driver responsibility assessment fee, which is an extra fee added on to these fines for certain driving safety infractions, or if you have a lot of points on your license. 42%, this is something we're really honing in on this analysis, were for failure to appear in traffic court. So this was, by far the most common reason for suspension overall. 7% were for failure to comply with some type of New York State or DMV regulations. So the most common reason in this category was insurance lapse. So a lot of suspensions for that. I got into this through studying child support, and 4% were for failure to pay child support. So in New York, your license can be suspended if you're 4 months in arrears for child support. And then we had 9% in reasons that, for reasons that we couldn't really categorize. There was a lot of heterogeneity, or if it was still pending. That went into this category. And I also want to point your attention to the fact that there, just in 2017 alone, 2 out of 5 drivers had suspensions for multiple reasons. And these end up being very costly and difficult to resolve. And mostly those were for failure to appear in court and failure to pay a ticket. A lot of drivers had suspensions for both reasons, either on the same day or on later dates in the subsequent year. Okay, so first question. First question was, what are the most common reasons? Clearly, they're mostly for non-payment and non-compliance. Second question, do these particular types of suspensions, are they more likely in racially and economically marginalized communities? Okay, so this is really fast. Okay, so this shows you, this is sort of a visual representation of what we found. So the figure on the left shows you how the zip code socioeconomic disadvantage is related to each of the 7 reasons for suspensions that we coded in the data. And on the right, we look at how the proportion of residents in the zip code who were non-Hispanic, Black, were related to each reasons for suspension. So the yellow line at the top there is for failure to appear in court. The red line is for failure to pay a ticket. The other lines at the bottom are for the other major reasons of suspension we coded. So overall, just what you should take away from this picture is that suspensions for failure to pay a ticket and to appear in court were much higher in zip codes that had a higher proportion residents who are African American or are economically disadvantaged, especially for failure to appear in court. So the results were most striking for that. So other reasons were also related to the racial composition and economic condition of the zip code, but just not as strongly as those two. Those two really stood out. And we did a lot of different models. We looked at percentage Latinx in the zip code and multiple suspensions, and we found similar patterns. So the answer to this question is yes, clearly related to the economic and racial composition of the zip code. Okay. Okay, third question, how are recent reforms that were enacted in New York expected to reduce these disparities? Okay, no, way ahead. Okay. Okay, so, all right, so in New York, the reform that was passed was called the Driver's License Suspension Reform Act. It passed at the end of 2020, implemented in 2021. Like many state reforms, it only ended suspensions for unpaid traffic tickets because I think the understanding was these are clearly related to inability to pay. Other types of suspensions that we saw were related to noncompliance were not covered, like failure to appear in court. Also, failure to pay the most common fee, the driver responsibility assessment fee, wasn't covered. So, and this is actually similar to what's going on in a lot of states, like focused mostly on unpaid traffic tickets. So we ran some predictive models to say, well, what would happen if both what do we expect to happen with the DLSRA that was passed, and also what would happen if we would have passed more expansive reforms. And I'll just summarize these findings for the sake of time. I'm not going to show you any of the results, but basically, we would expect this new law passed in New York that focuses just on tickets to reduce suspensions overall in communities most impacted, but that more expansive reforms, especially that include failure to appear in court, would do a lot more to reduce the number of suspensions and the linked inequality. So the next steps, we made 2 more FOIA requests for data to look at what actually happened after the most recent reforms that we're in the middle of analyzing right now. Okay, so the last question I'm going to look at here is what are key points of intersections with the criminal legal system? So here I'm going to bring in a little bit what we know from previous research and interviews we're conducting right now in New York with drivers who have had a suspended license. We have 2 locations, one in Monroe County, which is upstate where Rochester is located. And it has the highest suspension rates in the state, so we really wanted to find out what was going on there. Then we also picked one downstate location, Nassau and Suffolk County, which is on Long Island. And we've done 62 interviews so far. This is still very much ongoing, so I don't have any conclusions yet, but I'm just going to share some impressions from what we're seeing in terms of these links. So far, I think we're seeing 3 important links with the criminal legal system. First, that a suspension often originates through an encounter with police, through a traffic stop, typically. It requires people to answer a court summons and navigate similar court processes. However, people are often doing this on their own. They're just kind of trying to figure things out on their own and just kind of navigating this on the fly. And then a suspension can result in criminal penalties and consequences. So do you recall that I just showed you? These are, some of the most common reasons for having your license suspended. And all these I highlighted either started with a traffic stop, like a traffic ticket, failure to appear in traffic court, and then the DRA is usually a result of multiple tickets. Or people found out about this, might not have started with a ticket, but that's when they find out about it, when they're stopped by police and they find out that they have a suspended license. So a lot of these are originating through some kind of encounter with police. Okay, so in the paper, we look at how the risk of suspension is higher for communities who have more exposure to revenue generating practices in the police, the court system, and state administrative agencies. So I thought, I talk a little bit about what we know about how policing is used to generate revenue. So the Department of Justice investigation into the Ferguson Police Department after Michael Brown's death described these, discriminatory practices that in policing that were prioritizing revenue over public safety and were disproportionately harming low-income African-American residents who ended up getting caught in the cycle of fines, license suspension, and then sometimes incarceration. We also know from other research that there are more traffic stops and police violence during traffic stops in municipalities that are relying more heavily on fines and fees, and how this reinforces patterns of racial segregation. So when we started the project, we just saw this DMV data, and we saw that there, clearly some zip codes had a lot of suspensions. We went to Rochester. We looking specifically at the zip code where that has the highest suspension rates in the state. About 1 out of 3 adults in the zip code have a suspended license, and so we're asking, so I thought, okay, maybe this is like something going on with policing within the city of Rochester. But as we were interviewing people who, especially including who lived in that zip code, they talked more about driving. This happened when they were being pulled over as they were traveling outside the city. So outside the city boundaries, they're just trying to that's where the stores are located. That's where they're working. They're just trying to get to work or school, the stores and things. They're getting pulled over there. And some drivers certainly felt like they were targeting people who looked like they, didn't belong, who were non-residents in the community for these tickets. We, in our newer, DMV data that we got through a FOIA request, we're going to be able to merge this with patterns of traffic tickets where traffic tickets occurred, and looking at their proximity to communities that are more, heavily impacted by these suspensions. Okay, the next thing we're looking at is the court experience. So the Department of Justice investigation also found that a focus on revenue was really compromising municipal courts in Ferguson, that were using, to compel payments of fines, really imposing really harsh penalties for failure to appear in court. And like with aggressive policing, it was disproportionately harming low-income African-American residents. So in New York, suspensions can be issued by a variety of different courts and administrative agencies, including there are 1,300 town and village courts that are collecting about $250 million in revenue. These are largely outside of the supervision of the Office of Court Administration, and they're presided over by local elected judges, 60% of whom don't have a law degree. So what we're seeing in the Rochester interviews is that where people are being stopped is where they have to appear in court. So if they're just stopped just outside of the city, they're often appearing in these town and village justice courts. So like with criminal court, they're asked to, first of all, answer the court summons. Then they have to enter a plea. They have to negotiate with the prosecutor. They have to sometimes request a hearing. But they're doing all this sort of, really with very, very limited legal information or assistance, almost none. And then they're often doing this in courts outside their own communities. So just to show you what I'm talking about, okay, this is a map where Rochester is in the center here. And then the dots, I don't know if you can see those are the locations of the town and village justice courts that surround the city. I wanted to show you where those were, how they surround the city in the mostly white suburbs around Rochester. Rochester is in the middle. And one of these courts, which is, you can see the green triangle on the left. A lot of people were telling me, oh, we have to go to the Gates. We had to go to the Gatestown Justice Court because it is handling a lot of the tickets close to the highways. Gates is 89% white and but it's adjacent to this neighborhood with the highest suspension rates in the whole state. So they're having to travel to these courts outside of the city. So we're looking at things like their challenges to responding to a summons and appearing in court and navigating these court processes. In the newer DMV data, we're also looking at whether these courts are issuing more types of suspensions, especially when they're more heavily reliant on fines and fees. So that's what sort of the next stage. The third link to the criminal legal system is that it can result in criminal penalties and consequences. So about 75% of people are estimated to continue driving after they have a suspended license, which is not surprising because most people have to commute to work by car or get to do daily activities. And all states have penalties, including fines, jail times, or both for driving with a suspended license. This is a misdemeanor in New York. So what starts out as a very, very minor offense can actually pretty quickly lead to criminal penalties. And Sarah talked about how research on how having a criminal record can prevent people from being hired. But findings from the qualitative interviews show that this a mark of a suspension is also important, even if it doesn't result in criminal penalties, because employers are often asking people to show proof of a valid license, and they can also look it up online. It's on people's abstract for 4 years. And our interviews suggest this is really consequential for people's employment. It can lead to immediate job loss or being barred from a lot of jobs that require a license. And often, like Sarah was saying too, some people just opt out of applying for those jobs. This is a big deal because when we ask people for their history of suspensions, about 4 or 5 had said they had multiple suspensions. Some couldn't even estimate how many they had. They said 20. I don't know. So this is like something they're dealing with for many years, and sometimes their whole adult life. So this has cumulative effects. So just to wrap up here, what do we know? What are we learning so far? Suspensions affect a lot of people. Like there were just 1 million new suspensions in New York alone, just in New York. Most are for non-payment or non-compliance. Recent reforms that include both a failure to pay a ticket, but especially failure to appear in court would lower the number of suspensions and reduce the link to inequality. And then our interviews are showing important links with the criminal legal system, both in their point of origin, their experiences in court, and the consequences. So it has similar consequences and penalties as the criminal legal system, but I think it's affecting more people, and people are navigating these processes pretty much just on their own. So that's it. Thank you.
Hey, Becky, can you just give me 8 minutes? Court reporters say I talk fast, so that should come in handy here. Hey, everyone, my name is Ed Wunsch. I'm a staff attorney at Legal Aid Services of Oklahoma. I'm the criminal justice debt attorney there. I'm really glad to be here, even if my luggage isn't. What is a criminal justice debt attorney? I say that my job is to convince courts that impoverished people don't have money. My undergrad logic professor would say that's a tautology, and I'm like, yes, it is. I've been doing it 5 years, so they haven't figured it out yet. Last year, I got about $500,000 of fines waived for my clients. A couple of weeks ago, we had a $100,000 week. We're able to do a lot in Oklahoma, but on the ground, the biggest thing that I'm seeing that I think comes into play with all this research here is that people need to understand the system is on autopilot. A lot of the stakeholders don't know why they're doing it. They're just doing it because no one's challenged them, no one's told them. Again, they either don't care to be doing it that way, or and they could be open to seeing a solution there, or they are using the status quo to justify their job. I highlight, if those are the problems with it, you need to go ahead and think about making the solutions easy to implement, because again, you need to make the solutions to this as easy to be on autopilot as the problematic systems that we're dealing with. And then also we have to think about how avoiding regression back to the status quo. With that, I'm going to go ahead and respond to each of the wonderful panelists we have here. Specifically, going ahead and talking about pay to stay, this is a big problem I see there in Oklahoma. If you have a $5,000 bond, that means that if you could come up with $500, you could go ahead and bond out on that. But because you can't, great, we're going to charge you $5,000 to $10,000 depending on how long you stayed. So again, being poor leads to more costs and fines being assessed. How does that make any sense? When I go ahead and point that out to judges, it's very easy to get that waived, but it takes me standing there and pointing it out. Again, this is the system is on autopilot. We have a cash bail system, people are staying, they're the consumer. And again, I have to articulate, it's like, quite honestly, Judge, my client would rather not be in jail and not be a consumer. Maybe the public is the consumer. If we're saying that we're going to go ahead and house someone because we're concerned about safety or something, maybe that's because that's a public benefit, so the public should be paying for it. Depending on which court I'm in Oklahoma, that gets more traction in some places than others. But again, I'm just pointing out here that these systems don't make sense. And it's a matter of going ahead and confronting that on the ground, dealing with the fact that the system is on autopilot, and then finding solutions that can highlight that pay to stay doesn't make any sense if the people that are paying to stay are the people that can least afford to pay. Regarding criminal records, talking about the system being on autopilot, literally last week, a paralegal got a call from someone with our state police, the Oklahoma State Bureau of Investigation, complaining that we at Legal Aid, for people that were looking at screening to get them an expungement, we were submitting an accuracy check form that they could get their records for free as opposed to paying $15. First off, if you've looked at state police records, I have a problem with them calling it an accuracy check because there's not much accurate about it. But the fact is here is that this person at the state police was threatening fines and charges to people that share that accuracy check with anyone else because you're not supposed to. And I'm like, here's the thing, you expect any of my clients to be able to read this? They need to share it with a lawyer so that they can use it. Oh, and by the way, after we check accuracy, we will be using it to assist us with screening for expungement eligibility. But that is someone in the system who's calling us up trying to prevent access to these records because it's their job to collect $15. And again, I think I'm going to have some progress on that, but these are the sorts of things that when you're going ahead and looking into what are the barriers? Why are they there? It's the system is on autopilot. Someone's using this to justify why they're there when really I'm sure they can find something else for that person to do other than collect $15. But it's a matter of finding that solution. Regarding, I really appreciate your presentation, Karen, on voting in jails, because especially when I'm talking about my fines and fees advocacy, like, again, my job's really easy. You go ahead and explain what some of my clients are going through, and the judge is like, of course they can't pay. The problem is no one's asked before. And again, going ahead and talking about people who are incarcerated, like these are the people most impacted by what our legislature is doing, by what our elected officials are doing. Their liberty is taken away, and they don't get to have a voice because they can't access the ballot box. But that being said, I think that you also have to deal with the fact that some of my clients, when I first start talking to them, they're trying to tell me about how great they're doing. Oh, they can come up with the money. And I'm like, but wouldn't it be great if you didn't have to? Again, they're not used to having a voice in the system sometimes. And so because of that, again, I think that it is really incumbent on folks to make it easier for them to have a voice. And again, especially working with organizers so that, again, people are asking the question to the county auditors, hey, can you come into the jail to do this? Again, I think though it is the fact here that individuals in the system, like very often after their fines get waived, they're like, wow, like, they listened to me. And that's the first time. They've been in this criminal justice system for 5, 10, 20, 30 years. But with their public defender, again, maybe there was some reason why they got these charges and they're trying to explain, but the public defender knows that that isn't going to play a role in reducing a sentence or a plea, so they don't feel like they're heard. When really I'm going up to the judge and explaining, my client's not working because they're taking care of an elderly relative. And then I ask them the question, who would take care of that elderly relative if you weren't there? I don't know. Judge, they're doing a public service because someone needs to do that. And we don't want to go ahead and not have that elderly relative taken care of. So do you want them to pay you, or do you want them to take care of their family member? And it's, again, pointing out how much agency folks in the system have, and then empowering them to have access to the ballot box. Regarding license suspensions, as positive as I am about getting fines and fees waived, we just had a new bill that expanded license suspensions for non-payment and non-appearance. It's so funny because you look at how a lot of these aren't public safety things, they're not DUIs and things like that. Instead, it is, it's people that have these suspensions due to poverty. Again, why might someone fail to appear? They don't have childcare, they don't have transportation, they can't take off work. They're worried that if they show up and they can't pay, they're going to go to jail. And so they just don't show up. And so when it comes to talking about license suspensions here, the fact is that we're seeing this regression because the system is on autopilot. It thinks that punish people out of poverty. You can't. And so the thing is here with license suspensions especially, it's a matter of going ahead and getting involved with the stakeholders and showing them the data that people aren't not paying you because they're trying to stick it to the system. It's because they've got a lot of other higher priorities on their plates. And you going ahead and adding one more thing is just adding one more thing to justify your job, and it's not actually dealing with the problem. So again, when thinking about all of these issues here, one of the reasons I was able to get so much in fines and fees wiped out, and we've been able to see such a drastic change over the course of the past 5 years, is that when you point out these flaws, when you do this research and bring it to advocates that can use this on the ground. We don't have any direct funding for my position. We're using a little bit from over here that fits under this grant, a little bit over here that fits under this grant, but it really makes an impact on our clients, and it's through being able to rely on this research and confront the system with the fact that what you're doing makes no sense. And then again, some folks still want to stick to their guns when sometimes I feel like I'm not arguing against the DA, I'm just arguing against the judge advocating for the DA's position. And then I appeal. And I lose because it's Oklahoma, but I keep trying. Again, I just wanted to highlight here that I really appreciate all the work that the researchers and the advocates in this room are doing. I want to end with a quote that I try to use as often as I can from Chief Justice Berger in Williams v. Illinois. The constitutional imperatives of the Equal Protection Clause must have priority over the comfortable convenience of the status quo. All of you here in this room are the people that are there to challenge the status quo, and I just really appreciate all the work you're doing and look forward to continuing to have a dialogue about this. Thank you.
I think we have time for maybe a question before lunch. Is that right? 2 questions before lunch. Okay.
I feel bad delaying lunch. So thinking about, it feels like there's different processes to accessing data displayed on this panel. Some has been collaboration with government agencies, others has been open records requests. And I noticed especially for the open records requests, like Maureen, your project, ideally you'd have individual level demographic data, but it's having to corroborate using zip codes and patterns across zip codes. So I wonder just about, pros and cons of those 2 different approaches, and how do we think about collaborating with state agencies engaged in, these often bad practices versus just filing, FOIA requests against them?
Is this on? Okay, yeah. So I didn't have time to talk about this, but the collaboration for us started, and I think I forgot to show the thank you slide to all the people I should have thanked. I'm sorry about that. So on the thank you slide, we started by talking to, there's this coalition of over 40 groups in New York involved in advocating for the Driver's License Suspension Reform Act. So we started by reaching out to them. We worked with the National Center for Law and Economic Justice, who they had originally obtained the FOIA request. So we reanalyzed this data, asking questions that were, I don't know, so it was part of the original legislation in New York to include failure to appear. It was passed by the Assembly. Cuomo took it out at the last minute because he said, well, clearly this isn't related to structural, economic inequality. Anybody could appear in court, which, which we found is not the case. So we started through that avenue. But that was all pre-data. So to get the post-data, we had to make some FOIA requests. We started out, try it collaboratively, like people we knew in Albany, and we initially it was a very friendly response. So sure, we'll get the data, but then I think when they figured out what we were doing, we stopped getting responses to our emails, and then we made 2 subsequent FOIA requests to get additional information. The limitation of that is it's at the zip code level, so we can see communities impacted, but we can't see individuals. So that's why I think it was also important for us to do interviews to get the individual level experiences as well. So we're trying to get both the ecological and individual factors that I think are both implicated in license suspension. Whether we'll go back to the DMV, I don't know for a subsequent request, but I did ask them to put up my flyers for interviews, and they initially said yes, but I don't think it happened. So I don't know. So we tried other avenues.
Everyone's just thinking about lunch, I think.
So how about a round of applause for our panel?
My name is Nikole Summers. I'm a law professor at Georgetown, and it's my pleasure to moderate our next panel on data for achieving better justice outcomes. We're joined in the panel by Chiara Galli from the University of Chicago, Rebecca Johnson from Georgetown University, and Amy Widman from Rutgers Law School. And our respondent is Holly Stevens from the Legal Services Corporation. With that, Chiara.
Do I need to do anything to get the PowerPoint going? All right. Hi, everyone. It's a pleasure to be here. I'd like to thank Becky, Matthew, and Elizabeth for bringing us together once again. I'm one of this year's ABF JVP Access to Justice scholars, and it's been truly a wonderful experience to be part of this group. I think my research has benefited immensely from this experience. So I'm here today to talk to you about unaccompanied minors' experiences in immigration proceedings in U.S. immigration court. And as you can see, the title of the presentation is Deporting Children. So I'll be talking to you about their case outcomes, right? So what determines whether children are allowed to remain in the United States with legal status or whether they're ordered deported back to their home countries. And so I'll talk about the project in two ways. One is to present some of the findings on case outcomes, but also I'll talk a little bit about some of the data issues that we have and why it's so challenging to study immigrant children using administrative data from the U.S. Immigration Court, because the data really is very, very lacking. And so before I get started, I just wanted to acknowledge my co-author on the project, Tatiana Padilla. So unaccompanied child migration is on the rise. So since we started keeping track back in 2009, we've had nearly 750,000 unaccompanied immigrant children arrive at the US-Mexico border and be apprehended without their parents or legal guardians. But the vast majority of them come from Central America, so El Salvador, Guatemala, and Honduras. And so the next step for these children after they're apprehended is that they're sent to removal proceedings in immigration court, where they must fight for their right to remain in the United States. And they usually do so by applying either for asylum or a form of relief called special immigrant juvenile status, which is for children abandoned, abused, or neglected by one or both of their parents. So unaccompanied immigrant children, as you can well imagine, are a vulnerable population, and it's a population that's ostensibly protected under some of our immigration policies, and yet we do not guarantee these children access to legal representation, and hence they risk facing removal proceedings, adversarial proceedings in court alone. And as you can imagine, this is daunting for anyone who doesn't speak English, but particularly so for a child. And indeed, it's been very well established by past scholarship that access to counsel is kind of the fundamental ingredient for successful case outcomes in the immigration process, both for adults and for children. All right, so the project, the broader project that I'm working on gets at two research questions, which are pretty straightforward questions. The first is, what are the determinants of access to counsel for unaccompanied minors in this country where we don't guarantee attorneys to all children? And the second is, what are the determinants of case outcomes for unaccompanied minors? So who gets to stay with immigration relief and who is ordered deported. So again, these seem like fairly straightforward questions that we should be able to answer with our administrative data, and yet they're not. And so this is kind of the motivating energy behind this study. So with my co-author, we obtained access to a large administrative data set from the U.S. immigration courts through the TRAC, Transactional Records Access Clearinghouse at the University of Syracuse, which in turn obtained access through a series of FOIA requests to the courts that they've been doing since the 1990s. Now, this data has some major faults when it comes to identifying children that were introduced actually by an obscure procedural memorandum that the Trump administration introduced, which made it impossible to identify these children. So prior to this change in 2018, it was straightforward to identify these children in the administrative data. But since then, we have had no information about their representation rates or the rates at which they are being ordered deported from the United States, despite the fact that, as I've said before, this is a formally protected population of vulnerable immigrants. And of course, this data is extremely important, right? Not just for scholarship, but also for advocacy purposes. If we don't know how many children are going to court alone, how can we advocate for more funding to increase legal services for this population, right? It becomes very, very difficult to make that kind of argument. So with my co-author, we've come up with a way to try to find the missing children in this large administrative data set. And, I won't bother you too much with the details of a very tedious process of cleaning and collecting data, but we essentially use information from other sources in the administrative data, including information about, we saved the information prior to the 2018 changes that Trump made, that when it was possible to identify these children. We manually coded information on the type of dockets that listen to different kinds of cases, and so we're able to identify unaccompanied children in that way. And finally, we're able to exclude some cases of family members by using that kind of information. So we've come up with this kind of a method to identify this population, and it's a method that we think works fairly well, especially considering that there's really no other way, as far as we know, to find unaccompanied children in the data set. So you can see in this chart, so here in, I'm loud, so you'll hear it. So here in blue is our sampling method, so how many cases we're able to capture, and that's compared to the red, which is the number of children in the custody of the Office of Refugee Resettlement, so it's the facilities that detain these kids after they arrive in the United States. And you can see that the match is very, very good, at least until the year 2021, and then things start to change. But one of the reasons why we only capture about 40% of children after that year actually may have to do more with real world changes as opposed to the sampling method itself, because something that's happened under the Trump administration is, I'm sure as many of you are aware, we have this growing backlog of cases in immigration court that's reached actually 2 million pending cases. So what's happening is that a lot of individuals who are apprehended at the border and formally served a notice to appear on paper don't actually have a case that's been activated in court. And that's true for about 1 in 6 of all cases. And so it's actually the case that many of these children are supposed to have immigration proceedings, but they don't actually have them. So what does this mean in practice for them? It's a double-edged sword. On the one hand, it's better not to be in active removal proceedings because you're less deportable, if you will. At least the government isn't actively pursuing your case to remove you from the country. But on the other hand, immigration courts are crucial spaces in which children get access to legal services, where they find out about the nonprofit organizations that can give them free legal aid. And so by not sending children to court, you're kind of severing those crucial mechanisms that lead them to find access to what legal resources we do have for them. So, I think we're doing a decent job of capturing the population. So we've come up with this, just get this. With our sampling method, we're able to capture over nearly 500,000 cases of unaccompanied minors who have been in active removal proceedings in immigration courts between 2009 and 2023. And while I'll focus more today's presentation on case outcomes, I did want to share with you that we found that throughout this duration, right, since 2009 until today, and on average, only 52% of unaccompanied minors were ever represented during any point in their immigration proceedings. So this means that roughly half of these vulnerable children are going to court alone. Again, adversarial proceedings where they have to defend themselves. So really kind of a failure of the system. And we've also seen the representation rates dip pretty consistently under not only the Trump administration, as we might expect, but also during Obama. And this has to do in part with the fact that while we are investing a little bit more money into providing free legal services for these children, the numbers of arrivals are kind of outpacing those investments. Right. Ooh, I was doing so well. All right. All right, so now I want to tell you about, I have to get a move on to this. Okay. So what are the determinants of case outcomes for unaccompanied minors facing removal proceedings in immigration courts? So, oops. All right, so here, this is just a chart descriptively showing the deportation rates for children. So we found that over half of unaccompanied minors facing removal proceedings actually received a deportation order among the ones who had a decision made on their cases. And these, the deportation rate has fluctuated but increased pretty significantly under Trump, and then has also been increasing recently under Biden. So with this paper, my co-author and I are adding to this literature on kind of determinants of case outcomes in the immigration context. And as I mentioned before, it's been very, very well established by a lot of scholarship that legal representation is perhaps the most important determinant of a positive case outcome in the immigration system. We also know based on past work that grant rates vary across different agencies. So it matters where your case is heard, at what immigration court, what asylum office. It also matters who decides the case. So there's wide disparities depending on who the immigration judge is. If the judge has been appointed by a Republican or Democratic administration, if it's a man or a woman, all of those things matter. And we also know that it became a lot more difficult to win unaccompanied minors cases under Trump due to a series of policy changes. But so this paper is really contributing, kind of taking all of this research as a starting point and then contributing to scholarship that has started to look at how stigma and bias affects decisions on immigration case outcomes. So cases aren't just decided on the merits and the facts, like do the facts fit the eligibility criteria, but there's a significant discretionary component, and scholars have shown that judges can be quite influenced by these kind of stigma that are based on socio-demographic characteristics. So these are the kinds of things that we're trying to look for in this paper, right? Once we account for what we know matters, like legal representation and a series of procedural factors, how do children's characteristics shape their case outcomes? So we look at things like the effect of gender, age, the language spoken by the child's nationality, and whether the child is has been detained. All right, so let me move on. All right, so okay, that's better. All right, so this is kind of cut off, apologies for that, but you can see again about over half, 54% of unaccompanied minors were ordered deported. And these are what we call our positive outcomes. So about 4% of children were granted immigration relief by an immigration judge. And this terminated here, which is less than 30% of children were granted immigration relief by some other agency outside of the immigration court, such as an asylum office or a bureaucrat at the United States Immigration Services. So what these descriptives show you is essentially, again, as we know, based on past work, children who are ordered deported have much lower representation rates than children who have positive outcomes. So we did an analysis where we we created a dichotomous outcome variable where we, to model, let's see, all right. To model whether or not children are being ordered deported from U.S. immigration during their removal proceedings in immigration courts. All right, so let me jump directly to the results. So we, no, that was right. Here we go. Okay. So our analytic strategy is that we fit a multivariate linear probability model with robust standard errors and fixed effects for, I'm going to present this model here, for immigration court to kind of account for some of these factors that we know based on the literature, like that it matters where your case is heard, right, for the outcome of the case. So we account for all these factors and then look at how children's characteristics shape case outcomes. So let me show you our results. So we find that, again, consistent with prior scholarship, the single most important determinant of case outcomes is access to counsel. So children who are represented have 58% less chances of being ordered deported from the United States. And then after access to counsel, the second most important determinant of whether children are ordered deported or not is whether they have aged out of the detention in these so-called protective shelters that the Office of Refugee Resettlement detains them in and have been transferred to a detention facility for adults. So children who've been transferred to detention facilities for adults are 27% more likely to be ordered deported than others when you account for all of these other factors. We also found that unaccompanied minors were more likely to be ordered deported under Trump as compared to Obama, less likely to be ordered deported under under Biden, excuse me, compared to Obama. And we also find that age is associated with a lower chance of deportation. So in other words, it's the youngest children who are most likely to be ordered deported, which is a really tragic finding, I think. We also find that there is an interaction effect. So that basically there's an age penalty for males, but not for females. So teenage boys face particularly dire odds in the system, and they're very likely to be ordered deported. And we think that this is because they're being adultified by the adjudicators who are treating them like adults and ordering them deported at higher rates. Our results for language show that compared to Spanish speakers, indigenous language speaking unaccompanied minors have a higher chance of deportation, whereas English speakers have a lower chance of deportation. And finally, we see that nationality matters. So I'm going to skip a few slides so I can talk about the implications of some of these results. All right, so I talked about the gender thing. So in terms of language, it's interesting because we see that speaking English has a protective effect, and it's especially important when immigration judges are making the decisions about whether children get to stay in the U.S. Or not. And we think that this may have something to do with adjudicators thinking about the assimilability of immigrants as they decide whether or not they should be allowed to remain in the United States. Again, this shouldn't be a criteria for qualifying for asylum, but it looks like judges are taking this into account. In terms of this finding that indigenous youth are more likely to be ordered deported compared to Spanish speakers, this suggests, I think, both a disadvantage in terms of the language barrier, right? It's very difficult to find interpreters for indigenous language speakers in immigration court for these children. But it might also have something to do with the effect of being indigenous, right? It's very difficult, I found in my own qualitative work, for lawyers to represent indigenous children for a host of reasons that I don't have time to go into now, but I'm happy to talk about in the Q&A if you're interested. And again, we find that access to counsel is the most important determinant of case outcomes for these children. So I think I'm out of time. All right. So I'll just end on a note of saying that because this is a panel about the importance of data quality for access to justice, one of the major limitations that we have in monitoring the treatment of vulnerable groups of immigrants like unaccompanied children is the fact that the data is very, very poor. And the data the different bureaucracies don't communicate with one another. So we can't link what happens to children at the asylum office with what happens to them in immigration court. So we really have a very, very long way to go in terms of improving the data quality so we can actually study how these children are being treated in immigration court and to successfully advocate for them. Thank you.
Great. And can you do full screen? Awesome. Now we'll see if the clicker works. So thanks so much for having me. I'm Rebecca Johnson. I'm at Georgetown Policy School, but I'm a sociologist, not an economist. And really happy to be here, and thanks to the ABF and Becky, Matthew, and Elizabeth for organizing. So my focus is on the rights of students with disabilities in schools and how parents try to promote access to justice by helping enforce those rights on their child's behalf. So when we think about access to justice, a big theme is the use of discretion by K through 12 districts and schools in potentially illegal ways, and access to justice as a response to combat that illegal exercise of discretion. So districts and schools make a lot of decisions concerning students with disabilities, and each of those decisions is associated with the possibility that they'll make the wrong decision or exercise their discretion illegally. So one decision is which students have a disability at all, as defined by receiving an individualized education plan or IEP. Here, discretion goes in both directions. So there's potential overclassification, for instance, of Black and Hispanic males have been shown to be overclassified for disorders related to emotional disturbance or behavioral issues. There's also underclassifying, where a student does have a disability that deserves recognition, but it's not recognized through an IEP. Another decision is, okay, we got an IEP, we made it to that stage. Among the students with an IEP, what services does the district provide? So, you know, there are too few services provided in some children's IEP. There might be services, but they're inappropriately segregated, so they don't follow what's called the least restrictive environment provision of the IDEA. There is refusal to reimburse the special needs private school if the district can't provide appropriate care within its own schools. And then among students with an IEP, there's also the decision about when a student commits an infraction that would otherwise result in suspension, expulsion, or some disciplinary measure. What's the relationship between the student's behavior and his or her disability? So here, the illegal exercise of discretion is failure to recognize that behavior as a manifestation of the disability. So previewing some of the themes in Amy's talk, what I'm studying are due process claims in state-level administrative hearing systems. So this is a screenshot of a hearing decision from one of these due process claims within DC. So it's a parent who's filing a complaint against District of Columbia Public Schools or DCPS, seeking compensatory education. So in terms of access to data and using that data to study access to justice, under public records requirements, these hearing decisions are public. They're mostly posted on various state websites, but we know from talking to advocates, from talking to parents, that these hearings are just the tip of the iceberg. Most complaints that are filed do not result in a formal adjudicated hearing. Many are settled or withdrawn for various reasons. So it became a question of mine, okay, we have, these hearing decisions, we know that's the tip of the iceberg. How do we, uncover the iceberg or whatever the metaphor is and get disaggregated data on complaints that parents file in order to understand inequality in those complaints. So in terms of past research, there's research, really good research that consists of qualitative interviews with parents who have filed a due process complaint or have a child with an IEP. There's legal analysis focused on how the system is sort of stacked against parents in various ways. We also have data that's aggregated to the state level. So, we can do a state level heat map. I think it's highest in New York, largely driven by New York City. Also, New Jersey is very high, and DC. But we don't know, state level analyses have a lot of limitations in terms of comparing states between each other. So we want more disaggregated data. And my research has asked various questions, but this one is a very basic descriptive one of within specific states in DC, what are school and district level inequalities and parent oversight? So are places without parent oversight, and I'm defining parent oversight in this as just, the filing of a due process complaint. Are they true negatives? Are they places where there's nothing to complain about, everything's fine? Or are they false negatives in terms of underlying issues that affect the rights of children with disabilities? So going to the next slide, I filed a bunch of open records requests. These are filed at the state level due to where the cases reside. I had, grand ambitions that I would get uniform responses to all these requests, and I could just write code and, analyze all 50 states. It turns out each state, provides the data in a different format. So here I'm just focusing on DC. Despite the data appearing to come from a database, I received, I think, a 300 or 400 page PDF that was not, accessible via optical character recognition initially. I asked, could I just have an Excel spreadsheet or a CSV? They said no, and sent back the same 400 page PDF. So in terms of the unit analysis, it's individual filings that I aggregate upwards to schools, which is really nice because we can go, at the sub-district level, because within DC there's a lot of school level variation. I focus on school year 14-15 to school year 17-18. I'm currently working on pandemic and post-pandemic requests. There are about 1,300 unique filings across 124 unique schools in DC in this period. Different fields within the data, and then I look at the universe of schools that could have a parent complaint filed against them. So I'm not going to go into the methodology too much, and I already complained about it, so happy to talk offline, but basically use code to turn the 400-page PDF into data, merge it with other data, think about biases from that merging process, but feel pretty confident in that result. So moving to the findings, the first, basic descriptive finding is that when we aggregate, the counts of complaints or the count of oversight to the district or state level, we really obscure important variation. So, this number, 1,300 complaints filed against schools within DC, there's technically 2+ districts in DC. There's DC public schools and then the public charter schools, and then each charter school cluster can be its own district. But basically, if we aggregate that, we miss the fact that 45% of schools have at least one student with an IEP, but no parent due process complaints over this 4 or 5 year period. So obviously, then the question is, what are these schools? Are these schools true negatives? So schools where everything is great and the rights of students with disabilities are well protected, or are these schools potential false negatives? So there are issues, but there are no parent complaints due to administrative burdens, fears of retaliation, and the other access to justice issues. So this is obviously really hard because we know that complaints aren't, a good measure of the true prevalence of issues within schools. But then we need, some true measure of the potential prevalence of issues. So this is a first stab, but very happy for any and all suggestions. So I used the civil rights data collection from the previous school year before this multi-year window to try to characterize the no complaint schools compared to the schools that have complaints. And so the basic question is, should these schools have no complaints, or does that alternate source of administrative data, which is based on surveys of principals, and happy to discuss in the Q&A potential biases in that data source, but does this other source of data suggest issues that affect the rights of disabilities, but where there isn't this parent attempted adjudication or oversight via this administrative system? So what I'm starting to find is that the no complaint schools seem to actually look worse than the schools where parents have filed these complaints. So the gray bars, I know this is a bit small, are schools with any parent due process filings during this window. The red bars are places with no findings, and we see across two measures within the civil rights data collection, the mean disciplinary rates for 100 students, and the mean use of restraint or seclusion. So that's basically, inappropriately using very punitive techniques on students, are significantly higher among schools with no parent complaints than schools with parent complaints. And that it's definitely not zero in the schools with parent complaints. I don't want it to be misinterpreted as, parents are complaining about, issues that aren't there. But I think it's really striking that places with no use of this oversight system by parents are places that seem to have, real issues occurring. Interestingly, and I think related to DC is a somewhat unique context, there's not actually clear demographic differences between the schools with no complaints and the schools with complaints. And I think this is because there's already pretty limited demographic diversity within DC public schools and the public charter schools because of the integration with Virginia and Maryland. It's not like there are, particularly, there are some, a few schools with clusters of, many advantaged students, but a lot of the student population is disadvantaged along multiple dimensions. So I found this interesting. I was expecting demographic variation. So it's interesting to think about reasons we're not observing it in this context. In addition to the filing of complaints, there's also questions about the substance of complaints. So filings can be used for different reasons. So, the first filing is an example of a complaint focused on tuition for a special needs focused private school, which has, significant barriers to entry in terms of you first need to pay for the private school yourself and then seek reimbursement. So we know that's associated with particular measures of advantage. The other is about a school police officer who physically restrained a student. Police officers were summoned, the student was arrested, and despite some discussion about whether the behavioral infraction may be related to the student's disability, it was dismissed that that was a possibility. So I think related to the earlier panel on criminal civil justice intersections, it's interesting to think about this particular intersection and the inappropriate use of punitive school discipline and disability, potentially protecting some students from that more than others. So in terms of wrapping up, so there's a lot of limitations of this analysis. There's some that are addressable with the current data sources, but I think bigger than that, and why I asked the question earlier about open records requests versus working with agencies directly, the open records data has significant limitations that are addressable if we had access to, the raw administrative data from the DC and other education systems. So obviously, school level demographics are not a perfect correlate of student and parent level demographics. We also would be interested in student level measures of false negatives. So are there things revealed by other data sources that suggest, the potential violation of student rights, but no complaint was filed? Then also understanding the interactions that precede a complaint, whether it was, teachers sort of noticing something seemed to be wrong in terms of the IEP decision-making and them being the ones, obviously not to file a complaint, but to alert the parent to the presence of an issue versus the parent noticing the issue themselves. So yeah, a lot of opportunities for future research. and excited to discuss this in the Q&A. Thanks.
Hi, everyone. I'm Holly Stevens. I'm the Chief Data Officer, and I run kind of the team that processes data at LSC. So if you're a legal aid provider, an LSC-funded person, we're not going to talk about the GAR today. Don't worry. We're going to talk about the Civil Court Data Initiative, which collects data. And I think the theme, Amy, I'm going to steal from you, is the answer is we know very little, right, without a whole bunch of work. I think the themes from the papers and from what we're talking about today that emerged for me, and that I get to talk about with many of you in the room pretty often, is how difficult access is, right, to data, and how much time and effort it's taken all of you to get that data that you need from public data requests, then reshaping them, reworking your files, manually coding them. On our end, it's that request time and then going around the request, building data scrapers. We're collecting data from over 1,200 counties at this point, and each one of them, even in a unified support system, which isn't unified at all, actually, they all look different at every county, right? You get a new clerk in your eviction court, it starts looking different. The amount of work it takes to understand those things, process it, debug your scraper because it breaks every week, right? Because an update has happened to the website. Purchase data. Many of us are purchasing data or purchasing access to an API at the courts or with others to link our data together. The documentation issues and challenges, verification, validation, we could spend a whole nother panel boring everyone to tears who doesn't want to learn about all of those methods, right? And we'd all feel better afterwards, though, because we would have shared stories. And I think this skill required, I was at a legal aid organization that did research for 10 years. And the ways that we did that and kind of the ways that we do work now were so inefficient, because now there's data engineers, data scientists, researchers, others that are like, you could do this in a more efficient way. You could think about it differently. We could process the data differently. Many of us don't have that opportunity, right? And so I'm thinking about just the skill required to answer what Kira said. These are basic, straightforward questions. We're talking about the number of filings and specific things, how they ended. That one's a pretty challenging question, right? Right now, and my team has been spending a lot of time on just how many adult guardianships in one small jurisdiction were filed and how many were granted. As it turns out, that's a really complicated question. Like Rebecca, it's really complicated to just find out the most basic, what was filed, to think, what is happening here? And so I think the struggle for all of us is really, it shouldn't be this hard. We would really like to focus on more interesting questions about what's effective, the types of delivery methods, when and for whom, and under what conditions is representation effective, what kinds of legal service or legal assistance is needed. And instead, we're spending a lot of resources just answering the how many times is something happening in the courts. And I've been struggling with kind of trying to think about how to tell that story, because it feels like we're all saying the same thing about how difficult it is. And so how do we tell the story and actually get others to invest in those systems and think differently, while balancing this other theme that I think is emerging about privacy and access? I think two of the panelists today even add that we're talking about children. And we're talking about, in some of the work that we do, incapacitated individuals. And so the risk could be high in thinking about their data. And if we're talking about legal aid data, the permission from the clients to use their data in different ways. When do we give access to other researchers, and then what can they do with it? How far down does that go? And when do I get to pull my data back out? And thinking about that, I was having a conversation earlier this week about regulatory change, and not just about non-lawyers, but then even how you need to change regulation around intakes at the very beginning before you can even think about non-lawyer. And so really unpacking all of this requires so much landscape knowledge, both to understand the data, to think about the solutions, about the laws, the procedures, the local legal culture and actors, and just thinking about the investment in time that we all are spending from the bottom up to really understand these problems. It's such a significant amount of effort. And this session is called Data for Achieving Better Justice Outcomes. And so I was thinking about all of the researchers in this room doing all this work. And I came from academia before. I started working directly with public defenders and legal aid providers and thinking about how to connect the work to the better justice outcomes, right? How much of our work is being published, but isn't in the hands of the people who could use it to pull and push these levers about how to use their resources more effectively. We're reading a lot about when legal representation and the right to counsel and eviction can be effective. But in the data that I'm getting, I'm still seeing a lot of people doing work that may not be the most effective use of their resources. And if I send someone an article, it's behind a paywall. It's written in an inaccessible way for legal aid providers or court administrators to understand the opportunity that exists from the work that you all have done. And so I was thinking that final piece, final theme I'm struggling with a lot about the storytelling. I was talking to someone earlier. It's about communication and assistance to the people on the ground. And in the work that we're doing, we're trying to think about not just interesting research questions, but then sometimes we can just solve some of the problems that we were interested in researching. With the access to the data that we have, David Neumeyer's here, we've been providing data on a week-to-week basis to every grantee and non-LSC grantee who's funded by IELTA programs on eviction cases in Virginia. We've been talking to others in the field. How can we provide this data to you in a useful way and whenever you need it? Is it daily? Is it weekly? How do we build our pipelines to get you what you need to either do outreach differently? We're kind of populating court forms so that they can get, legal aid providers can text message or send an email to people they've already served to get their eviction expunged. It's a limited retainer, they DocuSign it, the form is populated, file it at the court. Like, we don't need to work, we can think about other ways to do the research on who's still not accessing those, but how can we shortcut some of these efforts? And then how can we also alongside do the research and give it back to the providers, questions that they're interested in answering, questions that they're asking about their own service delivery models. I think we know the court data is just a very small piece of the iceberg we were talking about. So many things don't get into any of the data sets that we have access to. And so how do we think about that work and the questions that legal aid providers are asking? We just at LSC, we have 131 grantees. For those of you who might not be familiar with LSC, more than a third of those have changed executive directors in the past year. And that is a giant opportunity to have people thinking differently. Those EDs have had access. Every Sunday, they get a report from their iPhone that says their data use, right? They are ready for more kinds of reporting and systems to say, what if I did something different? How would it impact both my workload, my staff's satisfaction, an ROI? You know, they're interested in kind of those kinds of questions and experimenting. They don't have the resources, right? So how can we think about the work that you're doing, getting it to them, connecting and building better partnerships to actually use this data to achieve better justice outcomes? And so I want to think about that storytelling differently and those connections. So how do we sell that kind of work and that experimentation to people? And how do we cultivate that kind of continuous learning that you all in this room as researchers already have? How do we cultivate that at an organizational level and build that muscle and look at that data and use it in a more efficient way with all of the skill that is in this room and on the teams that we work with? So, are there questions? Thank you. Yeah.
Okay, we can open it up for questions.
I'd like this soapbox for a minute or two. We spend a great deal of effort on helping self-represented litigants to understand their situation, the law, forms, get them into court. But what really will matter is how they're handled in court by judges. And I had a very strong feeling that the judges were getting it, that there's a universal doctrine from the state Supreme Courts that judge is to accommodate the needs of self-represented litigants. I myself wrote a monograph that ILS published on preserving the right to be heard, how judges can do this. But then, and we did videotapes, Bonnie Huff and Richard Zorza and I, of judges in the very, very best courts, how they deal with cases with two self-represented litigants. And that was used for training materials by the National Center and others. But then came Anna Carpenter's study a few years ago with 3 colleagues whose names I never can remember, and Anna despises it when I say Anna Carpenter at all. I just don't remember their names. But they did a study in 4 different courts, and they with where the states had different levels of guidance for the trial judges, and they found that the guidance level didn't matter at all, that the judges were universally abusive of the parties in DV final hearing adjudications. We heard her comments earlier about the importance of having a user satisfaction orientation within courts and people with a role of making courts user-friendly. How are we going to get that? And it seems to me that we need just the topic of this panel, systematic data, systematic processes, benchmarking, and regular feedback on the experience of people before judges. Emily Lagrada has done some interesting starting work on this of how to get feedback on procedural justice issues. And I know that the judges are going to fight this tooth and nail, hammer and tong. But Tom Tyler's research that was referred to earlier shows that it really is not whether the party won or lost that will determine the party's view of the proceeding. It's how they were treated. Did they feel the procedure was fair? So my soapbox is let's keep working on the research on judicial proceedings so that we know more and we can know whether Anna's and colleagues' findings are the truth, or if they are, how we can make them become untrue.
Did anyone want to respond? Any questions?
Hang on. I just wanted to let you know that the 2 cities that I'm going to be studying, these cities have both been doing satisfaction surveys. I have not. I'm going to request them through open records request, so I haven't seen what these surveys, what sorts of answers they get. But I'm very curious to see it, and I mean, I agree with you, but I think that we need to be doing that in lots of different ways, not just through the agencies themselves, because that has its own kind of, bias built into it. But I was excited to see that in at least in the possibility that data might exist. Again, I haven't seen it yet, so I don't know what form it's going to come to me in, but I thought that was a step forward.
Other questions, Becky?
So you've talked about 3 different very different kinds of settings and hearings, and you've talked about different kinds of actors who are data custodians who you have to deal with. And the reason you're doing this work is because there's some process or experience that you want to improve. And so I wondered if each of you could give us sort of, if you had one key takeaway about where what you're research tells you is the lever to act on this, where would we start? What that would be for each of your settings or processes or populations, wherever that might be in the problem. And it's okay, because you're not engineers, to say that the solution actually isn't in the problem that you're studying, that it's located in some other place.
Yeah, I mean, I think in the K through 12 education data space, we have a lot of sort of like structural facts about schools and districts. So we know, the demographics, the free and reduced price lunch percentage. We also obviously have a lot of standardized testing data. And I feel like what's really missing, and related to the last comment, are like measures of procedural fairness within schools and districts. So yeah, I guess my dream data source would be something that better systematizes interactions between school officials, parents, and students. Inappropriate school discipline, these rights violations, other things, which I think would be equally, if not more useful than state proficiency scores.
So I think the main thing that I really want to kind of focus in on, and I think it is built in a little bit into what I'm trying to study, which is that I feel like people need more assistance navigating government programs. But I think that assistance doesn't always need to be by a lawyer, right? It's inefficient. We don't have enough lawyers, and there's all sorts of other reasons that maybe sometimes lawyers can complicate matters, especially when it's non-adversarial by nature. So to borrow from, I think Nikole said earlier, like the right dose response, like I feel like calibrating, like what lawyers add, and then trying to maybe calibrate their use to that best point, and figuring out ways to expand assistance in other areas and in other tasks that are maybe better suited to non-over legalistic. And I feel sheepish saying this to a room full of lawyers, but not kind of making it more adversarial than it needs to be, and then hopefully getting that calibration right.
So I feel like you could go two routes answering your questions. One is how can we improve the process in terms of data transparency, and then another is how can we improve the process in terms of actually the broader process. So I'll go the second route. So, it strikes me that you can think about this in various different ways. Firstly, there's a broader question of like, should we even be talking about child-friendly immigration court proceedings, or whether children should be allowed to stay in the United States or deported back to home countries where they're in danger? Or perhaps that's not the conversation we should be having, and we should exempt children from these proceedings, which are adversarial. They're supposed to be civil proceedings, but the consequences are much more similar to a criminal proceeding, right? Deprivation of liberty, you're kept in custody for longer, or you're sent back to a home country where you might be in danger, you might be separated from your parents. So that's kind of one layer. Then if you actually want to kind of work within the system and solve the problem, of course, you could guarantee access to counsel to all of the children. Of course, you run into the problem that there just aren't enough immigration attorneys to go around. And so there's solutions like having accredited representatives represent cases instead. So one of the simple questions we've been trying to answer with this project is how whether accredited representatives represent kids as well as lawyers do, but it takes a lot of tedious coding of many long Excel files to do this. So I will be able to tell you maybe 1-2 years from now what the answer to that question is. But hopefully the answer is that they do a good job as well, right? Because then you can kind of expand access to services, because it's a very inscrutable process, right? Immigration law is very complex. It's as complex perhaps as tax law or similar to tax law. So this brings me kind of the final point to improve the process. Well, one could simplify the process, right? there's actually been a series of reforms to the asylum process in particular to make it more and more complicated and more dependent on really having legal representation to go through the process successfully. So if you simplify it, you would also have less need of legal aid, right, to be able to go through that process successfully. I do believe that children can't do it on their own, though, that's for sure.
We still have time for a few more questions. Yeah, right here.
It's not really, well, I'll set it as a question. So a while back, I tried to identify the different tasks that attorneys do and try to identify what's appropriate for a court to do and what are things that really an outside person has to do. And I wonder if that kind of analysis can be really helpful in thinking about, you know, what are those things that are special to the attorney role. Because also I'm thinking about in interviewing judges, I'm thinking of one judge in particular who said, I struggle when people hire attorneys that I think are jerks and like trying to say this person, you know, like they probably didn't know, right, who they were hiring. So, I mean, it isn't that there's a general perception if people have attorneys, they're going to do better, but not always the case in observations. But thinking about what those skills are and what other kinds of things come to the mind. And for example, in South Africa, you might have a judge who's hearing a case who's law trained, but in a case that involves a murder that involves witchcraft, there might be a person who is sitting there as a judge who knows a lot more about what that tribe thinks and, you know, whether that's a legitimate defense or other kinds of things. And with IEPs, I mean, having somebody who actually really understands special ed makes a whole lot more sense than most attorneys, right, coming into this. So I think it's a really interesting, you know, we traditionally get an expert witness or other kinds of people and try and bring it out in that way. But I just think it's a really important, like, what is that credibility that an attorney brings, or what are those factors that an attorney brings? And if we can start setting that and identifying those different roles, I think that might help us in moving forward with dealing with some of these issues.
Responses?
Discuss.
I think related to Amy's project, I feel like what you're highlighting is these multiple forms of expertise that are at play within these administrative hearing systems, and you know, in different contexts, it might be different types of expertise. So I think something that comes up in the education context is not only knowing about special education, you know, in the abstract, but like each school district operates really differently. So having this district specific expertise in addition to, you know, knowledge of like the laws on paper within the overall state. And, you know, I'm sure there are analogs within immigration and the different hearing systems you're studying. So yeah, I think that's a great prompt to think about, the topic specific forms of expertise.
I think that only works also if the other actors don't care if it's the attorney or not, right? Because we can separate those tasks completely. Frankly, the things that are being done in an eviction court is not because you're an attorney that you're effective, like the attorney work. It's because you're an attorney in front of the judge and they're hearing you differently. So I think that would be a great exercise, but unless the other players in the system are willing to hear the words differently from someone else, I think we're at a different starting point. So it's just not, we could go through the exercise and legal aid could operate completely differently, but the outcomes may not change in those cases if we had data to know that the outcomes, but separate.
But it might not be the attorney if there's a level of expertise.
I don't know if that's the case. Like, I think it depends on what type of case, but even we know in Social Security and other things and the work that Nikole, Alaska, I don't know if you want to comment.
Well, I think you're right. Like, the power differential depends on who the decision maker is.
Yeah.
But there are ways that data is very common in private courts where there are courts of different jurisdictions. So then somebody who's law trained and who's not, who has to be an expertise. So then you have like a decision maker has that should affect. And so if you have that, then that balances
Our balance. balance.
That balances that piece. So then you could have, you could imagine having other actors are more respected in that space as well. Like you can imagine not applying pressure. Like I don't want to know that child has to be business. Like why, why is it that a child we have a testifying witnesses, but why aren't you seeing the jurisdictions who has the subject matter expertise and the lawyer or the judge is there to guard the person. Right?
I wonder if that points to just a general different sense of curiosity, to Becky, to your question of like the curiosity of changing the way we do things and outlining who can do what, but also knowing what system you're working in the local culture, so that if you know particular power actors are only going to be able to hear from a certain type of expert, that you're still strategically working both to change that and to work within the system that you have, short of burning it all down. I think more curiosity about how can we push and pull strategically and where we work, test what we're doing, try and be more compelling in that messaging to the right people. And I guess my question is like, I think that would be great, but I don't know how you do that. You're playing whack-a-mole at all the times. The amount of investment, leadership, and ongoing commitment to that, it's a lot of work to work that way. It's a specific staff, both in the court and in legal aid, who want to work that way and that kind of thoughtful. So it's just it's a whole different kind of lab experiment in the different things. So I don't know.
So I think the agency context gives us a little bit of that lab exploration because it is interdisciplinary and because the culture and the norms within the agency, we can do things with this, the way we structure and design the internal agency kind of communication that can make that power differential, can kind of make it more horizontal instead of a vertical silo. And so I think that that's one thing that I find really interesting about studying the agencies. And there may be lessons there for court design too. I haven't gotten to that part, but it looks like you have.
Well, and also, there's also when we think about the community justice program, a lot of them look at the things that are not
Okay. I hope this is really good.
But it made me think that, one of the things our judiciary has done, our Supreme Court, is helping socialize the concept of community justice workers, right? So they had the conference where all the judges came together, and the Supreme Court justice who worked with us, sat with us and had me explain, and we held, all the judges talked about it, what would happen, and they were answer what questions they had. And also they're great. And, so they're really bought into this idea of socializing this within their courts. And they were like, when are we going to see them? And how is this going to work? And what will we do? And here are some things that would be helpful. And so I think that's one way too, to, if you can't get people with expertise up the chain, right, then you can also encourage the chain to endorse what you're doing because they're overseeing the piece of it. So if you've got a lawyer who's being a jerk to the person who's not a lawyer, the judge can intervene in that proceeding or in that and level set. In theory, we'll see. Don't know.
Okay. Any more questions?
Sorry. So I kind of have two disparate comment type questions. So the very first is I would echo the sentiment towards measuring judicial bias and how they deal with the other actors in the courtroom. I've been running a Housing Court Watch program here in Detroit in 36th District Court for the last year. And we are also a jurisdiction where we have begun implementing the Right to Counsel program, underfunded as it is over the last year or so as well. And anecdotally and sort of in a way that I cannot measure from my limited data set that I get in my 2.5 minutes of hearings, judges treat the different parties differently. And one of the main ways seems to be how the parties are speaking the judge's language, which is a lot of the function of the attorney, but also the way that the judges treat the pro se landlords versus self-represented tenants. Right, and those are sort of a level, a similar level of power that are treated vastly differently in my experience. So I would also be interested in something like, how do you compare unrepresented people in front of an ALJ versus unrepresented people in front of a judge at 36th District Court. And then sort of the other unrelated thing is that it would be really interesting, Rebecca, in your research on IEP work, to look at those sort of non-complaint schools and how prevalent the child welfare system is in those schools. Because children with IEPs are almost all children, in my experience, that are in the child welfare system have some sort of IEP, whether it's behavioral, emotional, or just a symptom of poverty. A thought.
Yeah, I definitely want to look at that. I think both because of, like fears of retaliation via the child welfare system, but also different administrative structures. And yeah, I mean, I think it seems like another theme is how ALJs or hearing officers or like the various officers or judges within these administrative hearings treat the parties. And a project I really want to do, just from anecdotal notice, is how hearing officers talk about moms in these decisions, because it's not treating them with respect, or it's not acknowledging their expertise or that they might have credibility. It's really like framing them as emotional and biased and things like that. So we'll see what I find.
To your first point, I just wanted to, what I'm starting to see a little bit anecdotally, and I want to dive into more, is that when the ALJs have discretion to decide whether a non-lawyer can represent someone, there tends to be anecdotally a greater acceptance of a non-lawyer representative for like a corporate entity. So like an HR person or an accountant, somebody that is representing somebody who already has power, as opposed to a non-lawyer, a pastor, a community, elder, or some sort of non-lawyer situation like that, representing somebody who's truly there alone. The discretion is an interesting aspect of that and how that discretion plays out. And so that, again, at this point, anecdotal, but I do think there is something there about that, which mirrors what you're seeing about the unrepresented landlords.
So in terms of a judicial bias in the immigration context, I mean, one of the things I was trying to get at with my presentation, so it's been very, very well documented by past scholarship that like who the immigration judges really matters for case outcomes. And there's work showing that, whether the judge was appointed by a Republican or Democratic administration matters, with, Republicans denying legal status to immigrants at higher rates than Democrats, as you would imagine. In what court is the court in a liberal city or not? There's been research by Emily Rio, who's a former ABF fellow, showing that women judges tend to pay attention to attorneys more than male judges. So a lot of that work has looked at kind of the adjudicator characteristics. So what my co-author and I are trying to do with this paper is to look at whether who the client is matters, right? Or who in this case, the immigrant child is matter, right? To what extent are the characteristics of the child leading to kind of some discriminatory behaviors on behalf of the immigration judge? And we find the evidence, right? Because we account for all of these kind of adjudicator characteristics. And then, we find that there's this penalty for teenage boys, for non-English speakers, for indigenous language speakers. And, so this is kind of newer research that's starting to look at that. And Emily Rio has another paper with Ian Peacock where they find that in the aftermath of COVID-19, immigration judges started deporting Chinese asylum seekers at much, much higher rates. And so they make this argument, right, that these are kind of stigma effects. And immigration judges are vulnerable to making biased decisions because of the conditions they work under, right? First of all, they're not really judicially independent. They're employees of the Department of Justice. They work with very, very high
caseloads tend to be quite burned out, have to meet certain benchmarks. And so they kind of are vulnerable to reverting to this kind of automatic decision making where you kind of lean on these biases, assumptions, and stereotypes about people rather than really having the time necessary to delve into the details of the case, really get to know an applicant and decide whether they qualify for a certain kind of relief.
Okay. So, oh, it's okay. I have some. Thank you. Yes. Okay. So, round of applause for our panelists.
This is our final panel of what for me has been a really inspiring and enlightening day so far. And this panel is on housing and environmental justice, which may not seem like things that go together to you. I happened to spend Monday with an unusual crowd for me, which is prosecutors. They're super nice. Anyway, one of the things I said to them was, now I'm going to talk a lot about civil justice, and you're not going to understand right now why this has anything to do with what you do, but trust me. So if you're a little bit skeptical about the relationship between housing and environment, it will be revealed over the course of our time together. So I have a wonderful panel with me, and I'm going to start at my immediate right, which is David Neumeyer, who's with us from Virginia Legal Aid and will be our respondent today. And to his right is Robin Bartram from the University of Chicago, who is succeeded, is that the way we say it? Is that what I said? Who is succeeded by Elise Barenthal from the law school at Wake Forest. And at the end of the table is Nikole Summers from the Georgetown University School of Law. And so we have a great panel for you, and we will go ahead and get started. Robin.
Hi, everybody. Thank you for still being here for the last session. So I am going to talk about some ongoing findings from my research that ties together housing and the environment, much like Becky promised. But really, what I do, my research is just a very small kind of slice of the pie when it comes to research investigating the relationship between housing and the environment. There's a whole bunch of stuff that focuses on housing and homes at risk from climate disasters, things like hurricanes, floods, and fires. There's also a decent body of scholarship that really highlights that the location of housing can be an environmental risk. So here I'm thinking about pollution from highways, etc. And also in terms of the infrastructure of housing. So things like lead pipes and lack of clean drinking water is another way that scholars have really shown the relationship between housing and the environment. So of course, all of these facets deserve the attention they receive. But I kind of focus on a slightly different aspect of housing and the environment. And really, I'm trying to make the case that we should be thinking about housing itself as part of the environment. So the built environment as part of the environment. And also thinking a little bit more about environmental risk that is slow, mundane, and somewhat invisible. So my first book looks at the inadequacies of building code enforcement in Chicago. I won't talk too much about it here, but the book really shines a light on the work of city building inspectors, and it explains the persistence of dangerous buildings. It explains why we still deal with slum-like conditions in cities like Chicago, even though building code enforcement was created over 100 years ago as a way to curtail slumlordism. And it also talks through sort of dangerous buildings, building fires, and why we still live with these issues. The average American spends an insane 87% of their time inside buildings. And building inspectors are the ones who are charged with enforcing standards that make these places safe. So ideally, building code enforcement insists on housing in decent condition and also doesn't impoverish people in the process. And this is really the kind of catch. So in my book, I show that even when inspectors, housing court judges, attorneys are really motivated to not punish low-income homeowners, this doesn't really do very much to help them make repairs or ensure their housing is safe. Similarly, when inspectors and housing court judges insist on repairs in rental housing in terms of sort of slum-like conditions, dragging them through housing court, for example, landlords very often raise rents in response, meaning that very often the most vulnerable tenants still end up living in poor housing. So the book basically ends up concluding, I'm doing this the wrong direction, sorry, that all ends up really saying, what's the point in building code enforcement if people can't afford to comply? The punitive system that we have in place clearly isn't working. Buildings still burn down, collapse at our sites of environmental risk. So this sort of slightly depressing conclusion led me to the research for my second book project, which broadly speaking looks at housing as a site of environmental risk, regulation, responsibility, and reward, beyond the context of disaster. So the book draws on interviews with a range of actors, from homeowners and landlords to people that work for grassroots organizations and city officials in New Orleans and Chicago, all of whom are dealing with aging housing stock in some respect. So an article from this book project came out last year, which draws on interviews with homeowners in Chicago and New Orleans. And the basic argument of this article is that the routine dilapidation of housing leads to displacement, prevents safe aging in place, and can exacerbate debt. So it doesn't take a hurricane for all of this stuff to happen. And I argue that we should really think about routine dilapidation and disrepair as a case of environmental injustice, rather than an issue of individual responsibility on the part of homeowners. So when I say environmental injustice, I mean all too common situations when some communities disproportionately are subjected to higher levels of environmental risk than others. So with a small research team, I set out to interview homeowners who are dealing with routine dilapidation. We spoke to homeowners who had applied for home repair programs, both nonprofits and through city government in Chicago and New Orleans. So they were really scant and hard to get. These programs do cover the costs of repair work for very low-income homeowners. Almost all of our interviewees were Black women over the age of 60. Their incomes were very low, often social security checks alone. And they lived in neighborhoods with histories of wealth extraction and institutional neglect that have rendered them contemporary areas of high poverty. So during these interviews with homeowners, I show in the article that routine dilapidation is a path of displacement, can prevent safe aging in place, and exacerbates debt. So in terms of displacement, first of all, my interviewees overwhelmingly wanted to stay in their homes for the foreseeable future. Many had lived in their homes for most of their lives and expressed a desire to stay for the rest of their lives. So for example, Sheila, who lives alone in New Orleans, told us, I'm going to live in my house as long as I can. I'm 94 years old, and I'm going to live here. I'm going to live in here as long as I can live. I don't plan to go to a nursing home. Yet without repairs to homes, many interviewees also felt like a move would be inevitable. So Adrienne, a 72-year-old homeowner, explained how the repairs to a 110-year-old home had helped her avoid foreclosure. I'm very happy the city offers these programs, she told us, because I probably would have been foreclosed on by now. If I had to pay for all the repairs I've been doing, especially the roof, I wouldn't be able to do it. I'd have to sell the house. Similarly, Val, who is 71 and from Chicago, and who told us her kids are in and out of the house, wasn't sure she'd have been able to stay in her home without her roof repairs covered by the city. You know what? I don't think I'd still be living here, she said, and she sort of trailed off as if this was the first time that she'd really realized this. So as Val and her counterparts reveal, the demands of routine dilapidation can put homeowners at risk of displacement. But while our interviewees wanted to stay in their homes, doing so poses problems without repairs. An absence of necessary repairs makes it really hard to safely age in place. Kimberly, a Chicagoan who cares for her grandson almost full time, told us how the state of her back porch affects them both. We didn't go out on the back door at all, Kimberly said. We haven't used that in years. 4 years now. 4 years we haven't used the back porch at all. And about her leaking roof, Doris simply told us, every time it rains, the water comes in. And then there was Wanda, who was our youngest interviewee, and she lives with her husband and kids in New Orleans, and she told us about her flooring. Because my home is old, she said, some spots on the floor is cracking or breaking, and I had someone go under there and it had rotted. At any point, I guess if I stomp hard enough right there, I'll go through the floor. So many of our interviewees, who remember, are mostly over 60, lived in dangerous conditions like Wanda and Kimberly, making their desires to age in place in their current homes dangerous. So critically, homeowners are in general expected to saddle the costs of repairs and maintenance themselves, which can easily cause or exacerbate debt. Many of our interviewees had spent considerable sums of money on repairs over the course of their lives. Some had refinanced their homes to cover repair costs. So Denise is one example. She grew up in public housing in New Orleans and then inherited her current home that had been her family for 3 generations. She told us how she ended up with a mortgage after 60 years of living in her home. My house was paid for, she said, and the contractor that fixed my house got me into another mortgage. Other interviewees went to additional lengths to fund repair work, such as high interest loans, credit card debt, and taking on additional employment. So Yolanda and her New Orleans home are almost the same age. Yolanda, I think, is 60 and her home is 70 years old. She had recently taken out a loan to repair her roof and siding. It's one of those credit card loans, she told us, like interest of 30% and all that. It was kind of backed up against the wall. So I just went on and made the loan a high interest loan. We also spoke with Cheryl, who retired years ago and lives with her friend and granddaughter in Chicago. She had recently gone back to work to try to pay off the credit card she used to cover the costs of repairing her flooded basement. I have to pay all this stuff back, she told us. So financially, it's not good. My credit card's up to $40,000. That's why I'm working another job. So as Cheryl, Yolanda, Denise, and others explained, the cost of repair work can have severe financial and life-altering consequences. And for me, these interviews really also expose that accessing a home, even paying off a mortgage, does not guarantee that homes remain affordable, an asset, or a safe shelter. In fact, I think routine dilapidation can mean a home is none of these things, and yet increasing access to home ownership remains a policy priority at the national and local level. And I think this makes sense in many ways, particularly considering that racial disparities in home ownership in large part drive the racial wealth gap. But I think it's also short-sighted as these policies do nothing to ensure homeowners can remain safely housed in homes that don't threaten their health or safety. I also think that overlooking issues like this to do with maintenance means we're really underestimating the affordable housing crisis. These houses are not affordable to many of my interviewees. So my research suggests that routine dilapidation is a disproportionate issue for Black women over 60. And this makes sense because of the history of racism and sexism in the housing market. These women also tend to live in neighborhoods of color in which the housing market has systematically undervalued their homes. And there is evidence that buildings sold to Black women, like our interviewees, were more likely to have needed repairs at the point of purchase. And they were specifically sort of targeted for these homes by real estate agents very often. What's more, racist and sexist hiring practices, disparate student loan debt, predatory and exclusionary lending mean that women, and Black women in particular, have been denied wealth needed to cover costs of home repairs. And I think that these facts should really make us consider whether homeowners like the women in my interviews should spend money on repairs if we can't guarantee they have a pathway out of debt or equity or profit from their home. But despite all of this, I actually also want to make a case that routine dilapidation is a feature of home ownership in general, because all buildings age and dilapidate, and it takes a lot of resources to prevent this. So it's really, I argue in this paper, it's really a feature of sort of individualized responsibility within our system of home ownership. It just has disproportionate impacts on certain people. So while the government allocates funds for disasters, there is very little in place, both policy-wise and fiscally, to protect against mundane aging and disrepair. So one thing I want to do with this project is to push us to think about environmental risk that is slow and mundane, and about housing as part of the environment, whether it's hit by a hurricane, threatened by a wildfire, or just kind of regularly aging and dilapidating. And the other thing that I'm really invested in demonstrating with this project is that homeownership is not just a one-off event, but rather a process that requires continual monetary investment to maintain. So the second article from my book project argues that well-maintained homes are not individual accomplishments on the part of responsible resourced homeowners, but rather subsidized by public and private financial resources. So I also have done a bunch of interviews with middle and high-income homeowners, and these really expose the wealth of loans, financial products, et cetera, that they can tap into. So for example, when we asked high-earning Chicago architect Martin how he paid for home repairs, he told us he had refinanced and taken out a home equity loan. You can't not refinance, he told us, when mortgage rates are 2 3/4. I financed a good deal of the renovations through equity. So to Martin's insistence that you can't not refinance with such low interest rates, you might add that you also cannot refinance at all unless you can jump through financial hoops such as good credit, income to debt ratio, and equity on your home to begin with. Things that have been systematically denied to the women in my research. Each of these are obstacles for households in low valued homes, and especially households of color, because of racism in the appraisal industry. So adjudications about equity, for example, rely on appraisals which favor white homeowners in white neighborhoods, much like Martin, who lives in a single family home in an affluent majority white neighborhood in Chicago. Similarly, Max, who is white and makes a high income working for a consulting firm, told us the following about how he pays for his home repairs. He said, we have a little bit of savings. My wife's parents gave us money to do it, pre-inheritance. They gifted us a certain amount and then loaned us a certain amount and then forgave some of that loan. We own a couple of rental properties that help supplement. We have decent jobs and savings accounts. We also have insurance. So if something catastrophic happens, we'll be able to tap into that. So Max can tap into an array of resources, few, if any, of which are available to the women that I mentioned earlier. But like other kinds of assistance available to middle class, wealthy, and white people, the kinds of loans and programs that enable maintenance are somewhat invisible and rest on huge racial and gender inequities in who can access them. So this map, for example, shows the huge discrepancy between Black and white homeowners for loans for repair work. So one white neighborhood in Chicago gets almost as much in terms of loans as all the majority Black neighborhoods in the city combined. So I think we really need to understand what lurks behind maps like these to see how the costs of homeownership not only negatively impact some groups, but work really well and advantage others, enabling them to avoid environmental risks, as well as a host of other negative things that come with routine dilapidation. But just to sum up, the overlap between climate change, inequality, and housing in the US is increasingly drawing attention. Climate change increasingly presents a moment of crisis, material rupture to buildings, to housing, from hurricanes, fires, and floods. But I think there's another, more mundane environmental aspect of housing inequality, what I call routine dilapidation. And this exacerbates the racialized and gender distribution of disrepair, renders housing more susceptible to other kinds of environmental risks. But despite its implications, I think routine dilapidation has largely flown under the radar. So we haven't really thought about the routine dilapidation of owner-occupied homes as an issue of environmental justice. I think this oversight is likely due to the individualization of home ownership, meaning that individual homeowners are held legally and morally responsible for repair work. But again, I think focusing on guaranteeing access to housing is not going to help, or not going to do enough to help, unless we can also ensure that everyone has access to resources for repair and maintenance as well. So I will leave it at that, and thank you very much.
All right, so when I was one of those idealistic law students, I thought that creating binaries was a helpful way of understanding the world. So I had all these different boxes: legal, illegal, civil, criminal, lawyer, ordinary person. And in this world of kind of do-gooders, which I desperately want to be a part, I divided things into tree huggers and people huggers. And I felt I was definitely a people hugger. And so it's somewhat surprising to say to you now that I've spent more than a decade working and researching on the topic of environmental justice. On the other hand, it's not surprising at all, because after getting my JD, practicing, going back and getting my PhD, and now having some teaching experience, I can tell you, binaries are a terrible way of understanding the world. They just don't work. And that is exactly what environmental justice teaches us. It collapses this realm of tree huggers and people huggers. It tells us if we care about economic stability, racial equity, liberty, clean water, clean air, we have to think about all of these together. We have to think about them as working in tandem. And so I'll tell you another area of binaries that has proved problematic, for me at least, which is thinking about this universe of justice is divided up into these categories. Thinking about environmental justice on the one hand, thinking about access to justice on the other hand. And so part of what I want to do in this presentation is talk to you all about what it might mean to think about environmental justice as an access to justice issue, how that can be effective for the environmental justice movement, how that can be effective for the access to justice movement. I'm at a crossroads kind of in my research. I'm making a pivot from the area I'm studying. And so I'm going to talk a little bit about what I've done in terms of my past research, the conclusions I've drawn, and why I'm thinking about looking forward, or changing direction, I should say. And then reflecting on what that change in direction might do to benefit our thoughts about environmental justice, access to justice, and more specifically, thinking about this as access to environmental justice. So before I proceed, I want to just take a minute to kind of define the terms. There are lots of ways of defining environmental justice. And so for me, I think about it as a conceptual discursive frame to describe, as Robin put it, the disproportionate effects of pollution, toxic waste, climate change, and other environmental hazards. This idea that not everybody endures the same burdens and not everybody enjoys the same benefits. And we often see these divides based on race, based on class, based on immigration status, based on gender. But I do want to say that there is a definition that has gained traction, particularly among the government officials that think about environmental justice. And that's the definition that was put forth by Dr. Robert Bullard, who's known as the father of environmental justice. It's a very legalistic definition, and it's worth keeping in mind as we think about environmental justice, which is, he defines environmental justice as the principle that all people and communities are entitled to equal protection of environmental and public health laws and regulations. I want to think about, so the environmental justice movement is not that old. It's pretty recently developed. And one thing I want to remark on is that even though it's come about pretty recently, in the 1960s, 70s, there's been an actual remarkable amount of success. And so we can think about the success in a couple of different ways. There's been a lot of momentum for environmental justice. I don't think saying this phrase, I'm saying anything that people have not heard in terms of rhetoric, in terms of description. So we have in the legislature, we have Cory Booker, who's thinking about the Environmental Justice for All Act. In the White House, Biden and Harris have made environmental justice a centerpiece of their agenda, and they're putting it forth with different agencies, EPA, DOJ. We're also seeing it in private industry. We're seeing private industries touting their policies as promoting environmental justice. And I mark this as a success for the movement. We now know what environmental justice is, and it's on people's radars. It's becoming an important thing that people are thinking about. Nonetheless, environmental justice, injustice persists. And I think that this picture is so evocative, not just of the kind of collapse between kind of social and environmental justice that I mentioned at the beginning of the talk, but reminding us that EJ is integrated with other social and systemic challenges, but also because whenever I see this picture, it reminds me of how long people have been saying that they can't breathe. And so if you think about this mask, I can't breathe, also thinking about it as I still can't breathe. And what I've been told so often by people who live in environmental justice communities is, look, you can put it in the legislation, you can have us to your meetings, but if the industries keep doing what they're doing in our communities, then nothing is really going to change for us. And this feeling of nothing really changing is persistent. And so despite the momentum of environmental justice as kind of politics, as kind of rhetoric, I think it's important to recognize that environmental injustice persists, and we have to start figuring out why. So I think part of the reason we're having a hard time figuring out why it's persisting is we're having a hard time figuring out what the issues are, why we have environmental injustice. Is it that we have ineffective legislation? Is it that the politics are a mess? Is it the very structure of the American economic system, capitalism? I think one way to think about defining this problem, which becomes really important to figuring out solutions, is to think about in terms of access to justice. Access to justice activists, scholars have been giving a lot of thought to how we define what's wrong with the delivery of justice. So here's a couple of ways that I think we might think about environmental justice as an access to justice problem. It gives us some analytical purchase to better understand the problems of providing environmental justice. So here's just a few of the ways we might frame it. complex technical and bureaucratic requirements. We see in access to justice literature, we see it in anecdotes from practitioners. It's really complicated. There's just so many procedural hurdles we have to go through. Exact same thing with environmental justice. You want environmental justice in your communities, talk about navigating a maze, go through bureaucracy and agencies that are supposed to help you with permits, are supposed to help you dispute what's going on in your community. There's not a lot of information or assistance for affected communities. That there's a real paucity of telling people, here's what the procedures you need to go through. Here's grants that you can apply for. Here's different ways of addressing this. Insufficient resources, I think, is just a standard problem anytime you're thinking about justice. There's just not enough people and there's not enough money to give to all those in need. A prioritization of process over substance. And this was a discussion that happened with the last panel and thinking about procedural justice. I think access to justice has given us a good way of thinking about justice as divided into procedural justice and substantive justice. And a lot of the complaints in the environmental justice realm is that what they have is procedural justice. They now have a voice. They are now called to administrative hearings. They now get to submit comments. They now have people saying we've considered the needs of the community. What they're saying is we're not having enough substantive justice. And I think this is a problem, and we now have a vocabulary if we think about it in terms of access to justice terms. Finally, there's also proposed remedies that lack standards and accountability and legal authority. There's this gung-ho sense of we have to bring in environmental justice. You must think about environmental justice when you're designing an enforcement plan, environmental agencies. You must think about environmental justice as you're going through permitting. And there is telling them what to do, but then actually holding people's feet to the fire. If you don't do this, there's going to be consequences. Or here's what it means to do this. Or perhaps creating a cause of action for people actually to sue about. So this is a problem. We have a lot of ideals, but not necessarily teeth to that. I think one more factor is to think about the way in which we've designed the government response to environmental injustice. So how have we defined how we respond? It's through administrative agencies. It's through environmental agencies. Who addresses environmental injustice? It's the administrative state. In a lot of ways, this is a practical necessity. It's practical because court actions have been remarkably unsuccessful. I think recent studies estimate that plaintiff success rate is 0.3%. And I think it's mostly because most of the lawsuits are brought under the Equal Protection Clause and under civil rights statutes, which have to show intentional discrimination, which, as you all know, is incredibly difficult. There is no environmental justice cause of action. They have to go through other avenues. So it's really been within the purview of environmental agencies. They develop rules designed to promote environmental justice in the community. They have environmental justice policies that theoretically guide their discretionary decision-making and implementation, enforcement of environmental laws. This grounding in environmental agencies, I think, poses some serious challenges for environmental justice. Agencies are under-resourced. They are incredibly sensitive to political changes. Incredibly sensitive to political pressures and lobbying. And increasingly, they're limited by the law in the exercise of their discretionary power. I'm not sure after this term in the Supreme Court, agencies are going to have discretionary power at all. So if you think about these are the people who are responsible for delivering environmental justice, they've got incredible hurdles to overcome. I think another significant factor that we don't think about a lot is the general culture within agencies. So I spent approximately 2 years conducting research of environmental enforcement divisions. There's a growing cadre of research which is showing that environmental enforcement happens less frequently and less severely in communities that are primarily Black, primarily poor, otherwise minoritized. And I want to figure out, can we have some kind of explanation beyond this kind of standard narrative of under-resources, political pressures? So I conducted participant observations, I conducted interviews, I worked with community groups, and what I discovered was a significant disconnect between what environmental justice aspires to, which is essentially a redistribution of environmental burdens and environmental benefits, and what agency actors view as their central mission and goals. So there's 3 major points that came out of this research. The first is that environmental justice is a principle, not a mode of action. So most enforcement staff acknowledge that environmental justice is unrelated to enforcement. As one staffer put it, EJ is a policy problem. It is not an enforcement problem. Respondents repeatedly point to the fact that their agencies have EJ divisions, and it was those divisions that should be grappling with EJ issues. It wasn't for them to be doing in terms of enforcement. Some respondents went even further in disclaiming EJ's role in enforcement, saying that it wouldn't contribute to the enforcement division's mission or enforcers' practices. So as one respondent with decades of experience in the agency leadership roles and enforcement work told me, if the environmental justice nomenclature didn't exist, we would still be doing what we do just as well. I'm not sure if all this EJ focus has really improved the quality of our effectiveness when it comes to environmental quality. I think even those who thought that environmental justice was important weren't sure how to incorporate it in their day-to-day practice. And as conversations unfolded, it became clear that even more than the question of whether environmental justice should influence enforcement was the question about whether or not environmental justice could influence enforcement. So on that question, another point came up, which is that there are too many barriers. Some respondents suggest that whatever the merits of including environmental justice in decisions about enforcement, they lack resources to focus more heavily or more specifically on overburdened communities. So one California agency staffer told me their division had only 5 inspectors for the entire state of California. So as they explained, we have to be very judicious about how we use our resources and make sure we focus on things that will have a big impact. Others suggested that bringing environmental justice into their decision-making was too political. They pointed out that this is for policymakers, it's not for enforcement staffers. And another big sticking point is the perception that environmental justice is a local issue. It has more to do with local ordinances and decisions than with environmental agency actions. So an example that came up repeatedly is residents who live in a highly polluted area who want agency staff to cite truckers who idle their engines in their neighborhoods are out of luck because that's not an environmental issue, that's a municipal zoning issue. So it's municipal laws, not state regulations, that dictate the remedy for their complaints. And finally, I think maybe most fundamentally, it's a question of whose justice. So I heard concerns about the incompatibility of administrative justice with environmental justice. People said that administrative justice has to be fair. Environmental justice, in their view, was inherently unfair because it privileges some groups over others. They summed it up with this idea that environmental justice is subjective, administrative practice is objective. And that really left me with a question of where we might go to find a more compatible and more effectively implemented notion of justice. And that's what's led me to this most recent project, which I'm at the very beginning stages of, which is actually environmental courts. These are a relatively recent innovation. They're designed to be specialized courts that hear only matters deemed to affect the environment, broadly defined. The aspirations, I will say, in establishing them are explicitly geared towards promoting environmental justice. If you look at kind of the mission statements, if you look at the press releases, they cite over and over again environmental justice. I thought this word cloud was really interesting. It was somebody who taught an environmental law class, asked their students, what do you think you'll get from environmental courts? And EJ, and environmental justice, appears again and again. So the promise of these courts is that they will somehow deliver environmental justice in a way that we're not seeing with agencies. I'll say internationally, environmental courts are well established. There are more than 2,000 environmental courts and tribunals in over 50 countries. They're less well established, but definitely growing in the United States. By my last count, there are about 15 environmental courts and tribunals in 10 different US states. So in the US, what do these look like? There's significant variation. We were talking about laboratories in the last panel. There's talk about natural laboratories. There's lots of questions about how jurisdiction, procedure, and day-to-day practice affect what we call environmental justice. Just by way of example, in Tennessee, the docket covers violations of local health, safety, housing, building fire, solid waste, and litter ordinances. In Vermont, it's hearing appeals from administrative boards and agency decisions. In Georgia, they address city ordinances pertaining to property maintenance, animal control, and other environmental degradation cases. They're very explicit. Their purpose is to protect and promote the natural environment, to enrich the quality of life for all citizens, to ensure that all claims and defenses are docketed in a timely fashion. So as I'm starting this project, I'm trying to think about, are environmental courts a way of accessing, opening up access to justice in a way that we're not seeing through the agencies? And so here's the broad kind of ideas and questions. I'm thinking about this in terms of 3 dimensions. I want to think about it in terms of thinking about the structure of these courts. How are we defining their jurisdiction? What kind of procedural rules are in place? What kind of evidentiary rules are in place? What's specialized about these specialized courts? I want to look at outcomes. Are we seeing a difference in outcomes? Who's winning? and under what terms are we defining wins and losses. And I also want to think about the experiences. One of the ideas about the environmental courts is here are judges who know things. They're experts. They know the place, they know the people, and that is going to create a different relationship. And through that relationship building, there's the opportunity to maybe build not just a victory in a case, but an idea of a healthy ecosystem and appreciation for the environment as a whole. I think that this has the opportunity of expanding our thoughts about access to justice. I think it gives us an opportunity to study a specialized court, to think about institutionalized design. Is there some way of which we can design courts that will make the delivery of access to justice stronger, better? Is this model going to give us some ideas that we haven't tried before? I think another interesting thing about environmental courts, when you get into the questions of environmental justice, what's at the center of it is often scientific expertise and science. And when we think about access to justice, we think a lot about access to law, to legal expertise, and to lawyers. And as we explore this, I want to think about other forms of access and opening up access to these other forms of expertise. And finally, I think it forces us to contend with a more holistic view of what we mean by justice. Justice for whom? Who's entitled to justice? Is it both human and non-human nature? It also gives us the opportunity to form some alliances across different movements. And those who are thinking about justice for non-human nature can become important allies in this broader access to justice movement. So I don't usually put all my contact information out there, but I really wanted to invite you to get in touch with me. This is the very beginning of the stage of the project. So this is really when it's most beneficial to hear from folks, to hear ideas. I'll say I'm still trying to think about is what I'm looking for, what matters. And I can read a lot in the literature. We all know academics sometimes get it right, sometimes they don't. I think a lot of people in this room have had the opportunity to say, I've been in this space. I can tell you what I think matters or doesn't matter in terms of thinking about whether or not courts are working or not. And the other thing I want to end on is another part of this project I'm thinking about is how do I take this information? We've been talking about data gathering. We don't know anything about these environmental courts, and I'm going to be gathering a ton of data. How do I make them accessible in a way that is useful? And I have some ideas, but I'd really welcome your thoughts about how do I get this information out there? How do I make it useful to you, to those that you serve? And so please be in touch.
Hi again, I'm Nikole Summers. I'm a law professor at Georgetown. And prior to entering academia, I was an eviction defense attorney, and that very much informs my academic work now. So I'm going to be talking to you today about outcomes in eviction court. And I'm going to start with a slide that I love to use in all of my classes. I teach first year property and a seminar on housing law and policy. And I use this slide in the classes I teach about eviction. And I start by saying to my students, so there are 350,000 civil cases filed in all federal district courts. So 350,000 civil cases approximately filed annually in all the federal district courts combined. And I then ask them to guess how many eviction cases there are filed annually across all the courts in the United States, of course, filed in state court. And the students usually start out by guessing something like 100,000. Tell them to guess again, then they sometimes say like 300,000. I was like, keep guessing. And finally, someone will say like 1 million, and everyone will laugh. And I tell them, in fact, there are 3.6 million cases filed annually in all of the state courts combined, and that comprises 22% of all civil filings in the U.S. Whereas all federal district court cases comprise 1%. And of course, that's what most of law school civil education focuses on. So most eviction research is focused on eviction filings. There's lots of research talking about the volume of eviction filings. It's been a lot of work to document this. Research talking about the demographic groups that are most likely to be subject to eviction filing, about the geographic concentration of eviction filing, the phenomenon of serial filings where households are filed against repeatedly again and again by the landlord. And we've learned a ton from this research. But what I want to talk about today is the need that I feel to sort of shift our attention somewhat, not totally away from this, but in addition to this, to really be looking at outcomes in eviction court, basically what's happening in all of those cases. There's been very little research about this, with the exception of some work that's focused on the impact of legal aid, that's therefore looked at outcomes, and that's looked at default judgments. But aside from that, there's been very little. So this is a picture from the housing court in Boston, which is where I am currently doing most of my research. And I really want to make the case that what happens to all these people who are facing eviction filings really matters. And of course, I think this is probably not the group that I need to convince that outcomes matter, but I will just make the case nevertheless. I think there are really three big reasons why we should care about outcomes of eviction cases. The first is the lived experience of tenants. So when I represented tenants, I saw again and again that what happened to them in their cases really mattered. It really mattered whether they stayed in their home or whether they were forced to move. That is a huge difference for low-income tenants. Second, it really matters, our understanding of the outcomes of the eviction system, eviction legal system writ large, really matters for our design of interventions and any evaluation we do of them. You have to understand the system and understand the outcomes it's producing to know what types of interventions are needed. Many interventions today that are aimed to reduce the overall rate of evictions are really interventions in the legal process itself. And so you're not going to capture the effects, many of the effects of these interventions without looking at outcomes. And finally, our understanding of outcomes really can and should inform practitioners' allocation of resources. So where limited resources exist, and they almost always do, as we know, it's really helpful to know which cases are likely to result in which outcomes, which indicates to practitioners where and which types of services are most needed. So this is what Nikole Nelson was talking about earlier in terms of sort of right dose response or rationing justice, right? We have to understand what's happening in these cases in order to be able to do that effectively. There's lots of outcomes we can study related to the eviction legal system. My past research has focused a lot on settlement outcomes. Prior to that, I was looking a lot at outcomes related to the warranty of habitability and claims tenants had related to the warranty of habitability. But what I'm focused on today is this concept of what I'm calling forced tenant moves. So a forced tenant move I define as an eviction filing that results in a court order requiring the tenant to move. I don't say eviction because there's really no consistent meaning of that word in the literature. Sometimes people use the word eviction to refer really to an eviction filing. Sometimes they'll use eviction to refer to an actual executed removal by law enforcement. So it's really just very muddled in the research. But this definition really captures what I think we should be focused on, at least in part, is those eviction filings that result in legal obligations for the tenant to leave their home. I think also we should be focused on the rate of forced tenant moves across jurisdictions. So the number, which I define as the number of forced tenant moves over the total number of eviction filings. So in other words, what percentage of all eviction filings are resulting in forced tenant moves, are requiring tenants to leave their homes. And I wrote a previous essay where I sort of made the case for why we should care about this metric in particular, which there I call the eviction court displacement rate. Okay. So there's a lot that we don't know about forced tenant moves. So we don't know how many filings result in forced tenant moves, what the rate of forced tenant moves is, where I started. We don't know how cases are resulting in forced tenant moves from a procedural legal perspective. How are you actually getting from filing here to that result of the person being forced to move? So procedurally, how is that happening? Who, meaning which tenants, which cases are most likely to result in forced tenant moves? And we don't know why, meaning why some cases result in forced tenant moves and others do not. So I explore the first three questions, which is why they're bolded, in a paper that's forthcoming in Law and Social Inquiry that's co-authored with Justin Steele, who's at the MIT Department of Urban Studies and Planning. We don't address the why question. That's a causal question, and we don't have the research designed for that. That's for a later day. Okay, so I'm quickly going to go through the sort of data and methods for this project. So we collected data from the Eastern Housing Court of Massachusetts, which is the housing court in Boston. We randomly selected 933 cases filed between 2013 and 2017, and we retrieved complete physical case files for all of those cases. And that was meant to be a representative sample from the jurisdiction during that time. We hand-coded case data across 36 variables to try to capture basically everything we could about the background of the case, the parties, the type of tenancy involved, the basis for the filing, and then all outcome variables we could glean from the case file. We then geocoded the files and matched them with 2017 City of Boston property assessment data and census tract data from the 2015 ACS. And finally, we conducted logistic regression analysis of a tenant's likelihood of being forcibly moved given an eviction action being filed. Okay, so we had I'm going to focus here on 3 research questions. We have more in the paper. The first question is, what is the rate of forced tenant moves? This is our starting question. Second is, what are the procedural pathways by which tenants are forced to move once an eviction case has been filed? And then related to that, to what extent does each procedural pathway contribute to the overall rate of forced tenant moves? And finally, once an eviction case has been filed, which case tenancy, property, and or neighborhood characteristics are associated with forced tenant moves? Okay, so I'll go through our findings. So first starting with how many, which is pretty straightforward. So we found that in Boston, 45% of all cases result in forced tenant moves. That's just the table that we have in our paper. That number may or may not be surprising to you given your own sort of priors and any jurisdiction you're familiar with. I found that number to be somewhat surprising given that Boston is considered to be this very tenant-friendly jurisdiction. It has, objectively speaking, some of the strongest tenant protections of any state in the country. So 45% I think of as relatively high, especially given that. So I think some places it's likely to be higher. Okay, so the next question is how. So again, how procedurally are tenants being forcibly moved or ordered out of their homes once an eviction case has been filed? And we identified 4 pathways, 4 procedural pathways by which tenants are being forcibly moved out. And this is just sort of a chart requested by a reviewer to sort of clarify this. So hopefully it's helpful to you if you can read the fine print, but I'll just sort of go through the 4 pathways. So the most common pathway is through what we refer to as a move-out agreement. Just what it sounds like, and I'm sure many of you are familiar with move-out agreements from your own experiences working in this field. It's just what it sounds like. It's a settlement agreement where the tenant agrees to move out by a certain date, and that becomes an order of the court, at least in Massachusetts. And so the options there are either that the tenant moves out on their own, or execution will issue, and the court will actually, the landlord will have authority to forcibly move the tenant out if they don't do so on their own by the specified date. So again, that's the most common pathway by which tenants are forcibly moved. Trying to think of which order to go in. So the gray line on here, another pathway is through violation of a civil probation agreement. So I have a whole separate article about civil probation agreements. Basic idea is that they're settlement agreements where the tenant agrees to abide by a whole host of conditions, and if they violate any of those conditions, the landlord can evict them through an expedited, sort of short-circuited legal process. And so 17% of all evictions in Boston are because of, of forced tenant moves are because the tenant has violated a civil probation agreement and a judge has ordered them out. The smallest share of forced tenant moves are from cases that actually go to trial where a judge adjudicates the case and decides on the merits that the landlord has prevailed in the case, and the judge issues an execution, again, ordering the tenant out. And finally, we have default judgment. And default judgment accounts for 34%, so about a third of all forced tenant moves in Boston. So that's the second most common pathway after move-out agreements. Okay, and then we get to this question of who. So which cases are the people, the cases that are most likely to experience forced tenant moves? Okay, so here's what we find. So I didn't put up, there's a table in the paper. I decided not to put that up, so that it might be just clearer to put up the results themselves. So what we found to be positively correlated with forced tenant moves, so basically to make the case more likely to result in a forced tenant move, were three factors. So cases with individual landlords, which is, I think, maybe somewhat surprising. There's been a lot of focus recently on corporate landlords and sort of problems posed by corporate landlords. But what we found is that, in fact, cases with individual, meaning non-corporate, non-public housing authority landlords, just individual owners, are actually the cases statistically much more likely to result in forced tenant moves as compared to cases with corporate landlords or cases brought by the public housing authority. We also found that fault and no-fault evictions were much more likely to result in forced tenant moves as compared with non-payment of rent evictions. Also, perhaps somewhat surprising, and I think noteworthy, because a lot of the attention has really focused on non-payment of rent evictions. Sometimes it almost seems as if that's the only basis for someone to be evicted. But in fact, we found that non-payment of rent evictions are the types of cases where the tenant's most likely to be able to stay in their home, and fault and no-fault evictions are positively correlated with the tenant being forced to move out. And then finally, this is probably not surprising, but we found that for non-payment of rent eviction filings, greater amounts of money being claimed owed on the summons and complaint was positively associated with higher rates of forced tenant moves. Interestingly, we found a couple of things that were not associated with forced tenant moves that we thought probably we expected to be. So to our census tract median household income. So we found that basically once the tenant's actually brought into court, the neighborhood household poverty level, median household income level is not associated with the outcome of the case. Similarly, we found that census tract racial demographics were also not associated with differences in forced tenant moves or no forced tenant moves. Again, that's sort of surprising given that both of those factors have been found to be highly correlated with the likelihood of experiencing an eviction filing, with facing eviction. We found again that once the tenant's actually brought into court, that's playing less of a role in the outcome itself. Okay, so I just want to spend the remainder of my time talking about the challenges in doing some of this research and why I think there's probably not more of it. And these really boil down to sort of three buckets of data collection, data analysis, and comparisons across jurisdictions. So data collection is a huge problem in eviction research. Data is kept by the courts across all of the many, many eviction courts that exist. It's kept in really, really poor form. So poor form. There are very few good databases to go to just be able to do this research, run the analyses. What I've had to do, and what most people who've done similar research have had to do, is to actually pull the physical case files, hand code the data on your own, and then use that data set to run any sort of analysis. That's obviously extremely time consuming and laborious, and makes for, I think, fewer studies of this type. Interestingly, I was contacted through the eviction lab by a computer science professor who runs a lab at MIT that works on LLM, language learning models, and she was interested in whether LLMs could be helpful with this sort of research. And so she asked for my raw eviction case file data and then my coding to sort of see if they could train their model to code like I had. And so I met with them. I explained like my process for coding this information. And midway through the meeting, she stopped and said, "Okay, I think this is going to be too hard for us, but we're going to try." And they did try, and they found that they couldn't train their model, that it performed extremely poorly. It could pull sort of basic information from the files, like the zip code of the address. Of course, that's on the summons and complaint, but beyond that, for any of the sort of outcome data, it couldn't do it. So they're actually writing a paper based on those findings now, using my data, which was sort of affirming in some ways to hear that, like, oh, I could have just like done, I didn't do that work for nothing, but then also very disheartening because like it would be so much easier if I didn't have to do this for the next project. There are also big problems with, so data analysis I think is hard in part because I really have always felt that I've always felt that I've only been able to do this research because I spent many years as a practitioner in the courts and could really read and understand the files. My co-author has a JD, works in the housing field. He could not really interpret the files the way I could just because they're so messy and legally complex. And I think that is a real barrier to being able to do some of this outcomes research effectively, because you really have to understand the nuances of the legal system that you're studying. And then comparisons across jurisdictions is quite hard because there's different terminology, there's different outcomes. It's really, really difficult to compare apples to apples just because of the jurisdictional differences in the legal regimes, in how things are done, in what terminology is used, etc. So I think there are a lot of barriers on all of those fronts, but I'm hopeful that more will take on this research. So thank you.
This is a wonderful presentation to me because housing is the principal work priority of most legal aid programs that I know, certainly the programs which I've been involved. Whenever you do a community needs assessment, priority setting process, housing, evictions, and conditions always come out as the highest priority. So it's a big deal for the legal aid world. And understanding more about the case variables makes a lot of difference for us, I think. I have some comments for the individual presenters on their own presentations, and then some questions for them as a group. And I will start off with Robin, and I just wanted to mention that among the causes that you mentioned, say, of loans for home repairs being unequally available, a factor in that is also air property. The fact that low income and minority neighborhoods, very often the ownership of a property is divided up between many family members, some of whom are no longer in contact. And so that not only slows down planned home repairs, but also it can stop emergency home repairs. FEMA will not loan money for a home repair granted if there's divided air property. Wanted to ask Robin to consider answering some of the following questions. She probably won't be able to reach them all. Can you describe some of the health and economic effects of the dilapidation? It's I think such a huge impact on our client population, but knowing more that's been published about those, I think is valuable for us. I want to ask about potential solutions for making loans more available to disadvantaged groups. I'm curious about the role of community-based initiatives and whether any of those has been successful. And for repair and maintenance programs to be widespread and effective, it sounds like a lot of money. How will they be funded? Going on to Elise and talking about the environmental justice. She mentioned 50 countries and 10 states that are already doing something in this order. And I'll want to ask if she has any examples of successes taking place in those courts that we can know about. And also mention the importance of expertise in how the decisions would be made in the environmental courts. Given the amount of specialized knowledge is available, I ask how would adequate representation, scientifically based, be available in such specialized courts? How would equitable access to scientific information be maintained so that both sides were playing through with similar knowledge fields. And then for Nikole, certainly intriguing is the finding that landlords are more likely to evict as an individual as opposed to a corporate entity, and interested in the reasons why that be, if that's been touched on in her research. Her focus on court-related moves, forced moves, makes me wonder if about 45% of the evictions are court-related. What happens with the 55% that are not? Maybe I'm misunderstanding that. I know in my practice, landlords will often just demand an eviction, demand a tenant move out, give them a date certain, it's often not very far off, and threaten to self-help evict if they don't move out. Turn off the utilities, put their stuff out, change the locks, do all those things. And those are certainly illegal in every state, but nonetheless, it's an effective threat, and tenants will want to move out that way. One advantage of sort of self-motivated move outs like that is that there's no eviction judgment ends up as a court record against the defendant, so future landlords are not going to find out about that. So there's incentive for a tenant to comply when the landlord chooses not to go to court, and why not examine the impacts of those as well. And there's certainly a challenge in data collection and analysis across different jurisdictions. And this is probably a hypothetical question: how can researchers obtain more uniform data? Because that seems to be a uniform problem across all of the fields that we're talking about today. So those are for the individual researchers. For everybody, I'm curious about what led to your interest, your personal interest in this particular topic or issue that you chose, and what is one primary thing that you would like for policymakers to know as a result of your findings. And could you describe any unexpected findings that have emerged so far for you? So that's it.
Thank you. So David has given you 3 questions. One was, what were you surprised by? Another one was, why are you doing this? Is that fair?
Yes.
Yeah. And then another one was, if we had policymakers here and you could give them one takeaway, what would it be? And so you can answer all or a subset of those, but it would be great to hear your answers.
I guess I can go first. I will answer the third of those questions first, which is, what do I think policymakers or people in those sorts of positions should know? And I guess that is just that the way that we handle building conditions, housing conditions, is just not working. And I would argue it's because it rests purely on a punitive system, as opposed to some other way. We might imagine building court, for example, housing court, where people were brought into housing court and, a court case or a hearing came with some money to actually make the repairs that people were in court because of. So that's that's one thing I guess I wish people knew. Do you want me to respond to the other points you raised? Sure, I'd love to. I think you asked about the sort of particular health and economic impacts of disrepair. I think they are many. In terms of health, all kinds of respiratory issues, from issues related to mold and damp, things like asthma, definitely exacerbated. A lot of sort of undiagnosed issues to do with headaches and things like that, that came up in my interviews with homeowners.
Also things like just, older people tripping and falling in their homes. I mean, these are sort of, they don't seem like they are serious issues, but things like that I think don't really get enough attention. And you sort of suggested that one of the responses might be a system of loans for home repair. And I would say no. I think it should be grants for home repairs or just funded home repairs as opposed to loans, because I think that loans are one of the ways that have got us in this situation in the first place. All kinds of predatory loans. And in terms of, yes, of course, that's going to take some money, but I think there's arguments that putting money into home repairs sort of saves public expenditure money because it saves money on things like cities having to demolish buildings. It saves money on sort of medical expenses to deal with the issues that come from disrepair. There are various programs, particularly in Pennsylvania, the whole home repairs bill, which is sort of funding homes for low-income funding repairs for low-income homeowners, and other states I think are trying to do this as well. I think this part is perhaps a little less likely to happen, but I also think that recognizing that people have and do make money from the situation is a useful way to go about thinking how we might fund it. So perhaps we could think about taking some money from the banks and the real estate industry that sort of targeted people for homes in disrepair and who have, not only targeted them for it, but like extracted profit and made money from it. So thinking about a way to perhaps even the playing field along those lines.
So I have just started this project, which means that I don't have a lot to say in terms of what I found in terms of data and surprises. But I will say the questions you asked specific to my project are exactly the kinds of questions that I'm hoping to have answers to. So this idea of example of successes, one of the things I've been thinking about is how are we supposed to define success? And I think that this is a really important question. And I think particularly with environmental courts, there's a lot of celebration, particularly with international courts. Look at how much better we do it. Look at how great this is. This is working so well in New Zealand. There's courts all over the world and it's beneficial. But what are the measures we have of success? And so I think that that's a really important question. Part of what I'm hoping to see across the US is with these different models, success in what terms and in whose terms. And I think the same with the role of expertise in terms of thinking about adequate representation. I think that there's some idea that by having these expert judges, these expert courts, that the judges are going to step in and fill that role in the gaps in expertise. Just like sometimes we think the judges step in and fill the role in the terms of lack of legal representation. I'm curious if there's any kind of innovations that are establishing some kind of other kinds of assistance or access to expertise, and if so, how well they're working. So I can answer your questions just by saying that I think that those are exactly the kinds of things that I'm hoping to kind of uncover with this study. And I think in terms of the bigger questions about why this interest and what would I want policymakers to know, I think the interest is that I feel, particularly thinking about environmental justice, we spend a lot of time developing solutions and not a lot of time examining the problems or defining the problems. And I think that this profound sense in communities that there is no environmental justice is coming from the sense of people keep putting Band-Aids in areas where there's not cuts and ignoring big gaping wounds. And so it's an effort to kind of think about what really are the issues. And I guess that would be the message, at least at this point, for policymakers. Let's stop and think about what the problems are before we jump in and try and think about how to develop solutions. But think about, are the problems maybe thinking in terms of the design that we have, in terms of the institutions in which we've located the response, in terms of access to scientific expertise. We need to step back and do a better job thinking about what questions we need to be asking and answering before we just deliver those answers.
Okay, I'll start with some of the initial questions you directed towards me. So first, in terms of, you asked a question about like the finding around individual landlords versus corporate landlords. It's a really interesting finding. I think what a lot of other research has shown, the quality of research around individual private landlords and eviction, is that they have a very high bar for filing in the first place. They often will try to work it out in some way with the tenant before filing. Like they don't have an attorney on retainer the way that corporate landlords do. Course, it's a big deal for them to actually go to court and file. When they what I think our research shows is what once they do file, the relationship is basically severed. They've done a lot already, and they want the person out in a way that is not the case for corporate landlords that just sort of file as a matter of course when the tenant has fallen behind on rent. So I think it sort of makes sense in the context of that backdrop of it being a personal relationship and there being this sort of high bar to file in the first place. In terms of the 55% number, so just to be clear, so what that finding is that 55% of the cases filed in court do not result in a court order requiring the tenant to move. Most commonly, the result in those cases, there are a couple of results, are that it's a civil probation agreement that the tenant ended up satisfying over time. And so they paid up what they owed, they complied with the conditions, the case is ultimately dismissed. A good percentage are voluntary dismissals from the start where the landlord decides to not proceed with the case, and often the landlord will actually file a voluntary dismissal. Those are a little bit of a black box because we don't know exactly what happened in those cases. I've actually, for a separate project, I've been interviewing landlord attorneys, and a question I've kind of thrown in there for this project is what's happening in those cases. And what they're saying is that for the most part, where they're big like corporate subsidized landlords, which a lot of them are, it's usually because the tenant has just paid up by the date of by the court date. Because there's a lag in Massachusetts. I think for like, if you see with the minority of cases where those are private individual landlords, where the landlord didn't show up, I think those are more likely to be cases where the tenant moved out. And that's why they didn't pursue, because of course those are the two options. But a very high percentage of those are these corporate subsidized landlords. And so I think they're sort of safe to assume that the tenant is still there. In terms of looking at cases that don't make it to court, so I think there's a little bit of jurisdictional difference between Boston and Virginia, in that Boston, I think informal evictions are much more rare, especially evictions, informal, meaning like illegal evictions where the landlord's changing the locks. Like I was just thinking about it. I used to work at this like community-based organization where tenants would just like come in with any legal problem, and I did that for I think like 8 years, and I can think of one time where a tenant walked in saying that the locks had been changed, or actually where in that case they were being threatened to be changed like that night, and we made sure that they were. So I think it's just a lot more rare, in part because the consequences in Massachusetts are really severe for landlords that do that. There's a lot of like education out there generally for landlords, and the Attorney General has historically been very aggressive on that. Informal evictions, of course, where people are just like sent the preliminary notice and move out in response, we don't really know how often that's happening, though there is research from New York. So Matt Desmond has this sort of famous paper where he showed that there were twice as many informal as formal evictions in Milwaukee. There was then a study done in New York City finding that there was actually a very low, the rates were flipped, but even more so that like there were way fewer informal than formal evictions in New York City. I think Boston is a lot more like New York City because it's a really tight rental market. Tenants have nowhere to go. And there's the illegal evictions are much less prevalent, so landlords don't have that same threat, is just my guess. And again, sort of informed by the tenants I saw just sort of coming into these meetings. But I think that sort of like the reason why I don't look at, my research is generally focused on what's happening in court and what the court outcomes are. I think it'd be pretty hard to study those cases because they're not cases, and how do you even like identify the scope of what's out there? It's just like a completely different research project. But I also think there's a lot of value in showing, we have 3.6 million filings a year. I think we should really understand what's going on with them. Of course, like other people can do that research too, but I think there's value to understanding what's going on in courts, especially given that that's where I think most interventions are targeted at changing court outcomes in some way. And I've talked for a while, so I'm not sure what else to say. A takeaway for policymakers, I will say I think like there's a lot of attention. This is sort of sideways from what I've talked about so far today, but I think there's a lot of excitement around like mediation in court being a like cure-all, and I like frequently say when I have any sort of policymaker audience that is far from a cure-all, and a lot of these cases do go to formal mediation, and I think it makes very little difference.
Great. So now we have an opportunity for questions from our other participants. Yeah. Ed.
Ed Wunsch, Legal Aid Services in Oklahoma. I feel really bad because Robin was a great moderator and now I'm giving her probably a tough question. So you mentioned the idea of going ahead and taking money from the people that are profiting off of these systems and whatnot. And that reminds me, it harkens back to like the national mortgage settlement and the foreclosure crisis where, again, you had billions of dollars of relief, principal forgiveness, loan bonds, all of that. Again, that came about through threatened litigation from all of the state attorney generals. That's one model. I'm wondering if you've thought of any other models on how to go ahead and do that through regulation, taxation, and then obviously how to deal with what happens when those stakeholders push back. And then again, as you're thinking about ways to fund this way to repair homes, again, is there any model that we can start on that someone's found successful? Because again, we need to do something and I'm just not sure what.
Thank you for those questions. In terms of your first question, I have not. I wish I had a fantastic, thought out idea of how to actually do what I propose, but my proposal or suggestion is just more of a kind of a dream of mine versus something that I think is particularly possible or likely, in the near future. And you asked about a sort of model for what might be working, and I would just point you towards Pennsylvania's whole home repair program, which was a bipartisan bill that passed a couple of years ago now. And so they are people that work in various departments in Pennsylvania are doing a lot of work right now to evaluate what's going on, to try to sort of advise other states who are trying to follow their lead. But basically the program is, I think, $126 million of funding for low-income homeowners and small-time landlords. I think they are eligible for up to $50,000 in repairs to a single building. And of course, that isn't enough. It's a lot of money, and it's a sort of a huge achievement. But of course, that isn't enough. But I think it's a start, and I think it's an exciting start, particularly because of the sort of the bipartisan aspect of it. And in talking to the people who proposed the bill initially, one of the sort of useful, depressing but useful things about disrepair and issues related to housing conditions is that this isn't just like an urban thing. This happens all over the country, in rural areas, urban areas. So it's actually something that is gets relative consensus among Democrats, Republicans, etc., as being an issue that needs a solution.
Thank you. What else? And I teach for a living, which means I can stare at you silently for a long time until you talk. And I will.
Keep staring at me. So I think the two concepts that kind of resonate for me are around this kind of environmental justice concept of slow violence and structural violence, like the ways in which both the environment and degradation can happen sometimes invisibly, or it's not often experienced as collapse. For example, in structural violence, sort of institutional prevention of basic needs. And the way that we design civil justice interventions is often targeted at a specific kind of transactional engagement with a client, right? Like fixing an eviction or helping someone with an eviction, rather than understanding the broader ecosystem of needs like poor health or loss of a job or sort of other things. And so I'm wondering if you have insights from your research about how you think we might do a better job of maybe not designing solutions necessarily, but better understanding the problem space for designing solutions in ways that the environmental justice or perhaps housing justice spaces have done a better job of figuring out, or at least helping us to see, making visible some of the more structural issues.
I love that question. I think I would love to have that. I feel like we really need that perspective when it comes to eviction. I think we really think that why question that our paper is not getting at, I think is super important. Like, why are these cases resulting in eviction, or why are they getting filed against to begin with? So I think there's this, one thing I've observed a lot is there's sort of theory that eviction is really just about lack of affordable housing, right? Which I think in part, absolutely, right? But you actually look at the data, and a lot of these cases are evictions filed against tenants in public housing or in subsidized housing who like definitionally already have affordable housing, right? And whose rent should be adjusted with their income. So clearly that's not just what's going on, right? There's something else more structural or deeper than it just being an affordable housing problem. And I think no one's really like interrogated that. That's just sort of this like maxim of like evictions, that equals affordable housing problem. And again, like partly yes, right? But I think that's not the full story. And I think we need to get deeper. So I guess I just like agree with the question and then need to adopt that perspective when it comes to eviction research.
I was just going to add really briefly that I think that this is one of the strengths of environmental justice as a frame, because it calls attention to that. It says, we're talking about transactions, but really let's not forget all the other things that go into the systemic, the structural violence. And I think that's one of the things that I really appreciate about kind of Robin's work is this idea of there's something different about talking about housing justice versus talking about environmental justice. And it might sound like it's just a rhetorical shift, but I actually think it does a lot of work in terms of an ideological shift. And it's one of the things that I've been thinking about is what does it do if we start thinking about environmental justice? Because it does bring in a broader kind of lens for thinking about the same things that we're thinking about and talking about and concerned with, but it brings in other perspectives just by the virtue of using that label, and it brings in other kinds of movements and groups that are thinking about it. And I think that does real work. And so it's worth doing that. There's a risk too, though, of then making it encompass everything. And so there's this balance you have to hit. But I do think environmental justice kind of gives us a way of talking about what we're already talking about, but bringing in all these side conversations that are actually the central conversations.
I'm not sure I have too much to add, so I won't sort of blabber for no good reason.
Hello again, Eduardo. So trying to think about my question, I'm recalling this article of like some very wealthy people spending like 500 million to put a sandbank to protect their really expensive house, and it was like washed out in like one day, right? And I was struck by, I think, the diagram of like, you know, the equivalent amount of subsidies were given to really wealthy homes versus a huge group of these counties. How are we talking about that story where it seems like everybody interested in environmental justice is trying to be more responsible about how we're spending money to combat climate displacement? But then we have like a lot of wealthy people spending tons and tons of money wasting potential subsidies on wasteful practices that are not, you know, taking into consideration in climate change. So how can we show that data of like more of these subsidies should be spent on poor people to help them move to safer places rather than subsidizing really wealthy people to stay in a house that they spent too much money on? That is like where my question went. But it's like the incentives here are like, we need to be, you know, deficit focused for poor people, but then we need to protect all these assets, even though we know that they're in climate prone areas. So that's where my question lands.
Yeah, I think you kind of, in my mind, the answer to your question was sort of embedded within your question, which I think is just, for me at least, one of the, I think an important thing that I want to try to do is to just really expose all of the like the subsidies and the resources that people who are already fairly wealthy get in order to spend on their homes, whether it's effectively or not effectively in terms of climate stuff, in terms of repairs or whatever. But by sort of exposing that it isn't just the fact that, you know, a homeowner is responsible and is doing the right thing by maintaining their home and mowing their lawn or whatever. It's like everyone, like pretty much everyone needs to tap into some kind of resource. Let's talk about mortgages. That's a subsidy. That's a loan. You know, that's assistance. And so it's trying to sort of like expose that half of the coin to try to sort of reveal the mismatch between the two halves of the coin, I think is the first step at least.
Other questions? Yeah, great.
think I'm doing a pretty good job yelling, but other kinds of like data collection through the courts, by the courts, some other way that we could think about trying to do more consistent, accurate data collection on a local level that doesn't require enormous expenditures of capital, of labor by the very few researchers who are doing this work.
Thanks. That's also a great question. So I think, like you say, I think it's really jurisdiction specific. I think like in my ideal world, what would happen is that locally there would be like a team of advocates and people on the ground who come up with like, these are the variables that most matter to us in order to be able to understand what's going on at the system writ large. And I think those are going to be different everywhere, which is why I think it should be done locally. Like I could tell you what I think they should be in Massachusetts, they would be different everywhere else, right? But like these are the variables that the court should really be recording for every case. And then the court should develop a system that actually records those variables. Because I don't think, like I quoted 36 variables, that's not a ton, you know, that easily could be done by the court. It's just that what they input is not what is going to be helpful from a research perspective. So I feel like if there were some real, like if courts were invested in this research and would be willing to work with local groups and develop a system like that, I think it actually wouldn't be that hard for courts to be able to record the data in a way that researchers could just like get the database from them and use it. And some courts do a better job than others. Like New York City has like pretty good data. It's not like perfect, but it's a lot more detailed than like what exists in Massachusetts. And you could do like some of this like basic like outcome research, I think, with the administrative data sets. So I think just that, because I don't think you need like, you know, for example, like settlements are just so messy and they're like often handwritten. And so like, what could you do? Like require that they all be typed up? Like, I don't think so. I don't think that's realistic. Require that like every term of the settlement be input by the court. Again, like not realistic. So I think it's just like, ideally you want jurisdictions to really choose like what variables matter and get them to record that.
Probably have time for one last question or comment. If someone has one. Yeah, Margaret.
Yet, even if MIT's best attempt at building an LLM for data analysis is not there, I think we can safely assume that that capacity is going to be growing. So what we need to do as a community is to prepare the data sets. So all of those amazing case files you pulled, how can we have an open repository that's as protective of people's identity as need be, but that we have kind of training data sets, ideally even with like expert hand annotations, that we can get more technical partners to automate these processes. But even if it's not there yet, we need to be laying this infrastructure. And I think efforts like New America's Eviction Data Initiative, where they've done a several-year stakeholder convening groups to figure out across jurisdictions what are the common data elements that courts should be collecting to have better eviction policy. And now I think they're going to be issuing their guidance, again, across jurisdictional effort that can be localized, but to start then allowing hopefully for more apples-ish to apples-ish comparisons, having that investment and payoff from a think tank like New America. Hopefully we'll have that payoff. Yeah.
Any reactions? Okay. All right, let's thank our panel.